What is going on, y'all? How we doing, McKinley?
Great. How are you?
So good. So good.
So good.
So good. Checked on the goats before we got on here. They're doing awesome. Made sure they got new hay, filled up all their waters because, you know, now that I got a mama locked in a stall, they've lost a water pail. So I got to do it twice a day. No worries.
Oh.
It is what it is. But guess what?
What?
We're going to finish this trial today.
Yes, we are.
Yes, we are. We're in the last day of not even testimony. We're going straight into jury instruction. And we're going to fast forward through all the arguing over what the jury instruction is, y'all. We're just going to give you the actual jury instruction. And then we're going straight to the verdict.
Mm-hmm.
So this is it.
The jury instructions are long and complicated and enough sure. As it is.
Well, there's a crap ton of charges in this case. So, it makes sense, I guess. It's going to be a little tedious in the morning, but then we're going to get to it. We're going to get to the verdict today, and we're going to be finally done with the Elijah McClain trial saga, at least until January 5th when they do the sentencing of the officer. I might stream that. We might stream that. I don't know. We'll see.
What? Oh, the sentencing. Oh, you know.
Well, I do now, but the sentencing for the officer is what I said.
Oh.
It's okay. Last night, Mrs. Valhalla, I got off stream and she was like, "Oh, that happened, huh?" I was like, "What?"
My mom sent me a text message as soon as the verdict comes out, and she's like, "Oh my god!" So, and I was like, "Well,
let's not put it out there quite yet, I guess.
I'm sure everybody knows, but yeah."
What's up, everybody? Hey, John, how you doing, brother? Good to see you. Miami, love ya. You're amazing. Legally Live is in the house, of course. Flash fan, what's up, buddy? How you doing? I'm good. Danielle, hello, lovely.
Okay, I just realized that this Danielle is the Danielle from the stream. Yeah. Last night.
Yeah.
I had no idea.
No. Well, now you know. Now
I know. That's
She's
exciting.
Danielle with the little D. There's also a Danielle with a big D that kind of runs in the same circles on YouTube.
Okay.
They're not the same. Little D Danielle is from Florida. We love her. Big D Danielle, I don't really know anything about. I don't not love her. I just don't know her.
She's just not
Texas
on stream.
Jen. Huh?
She's just not ever on streams.
I don't know, actually. I'm not sure.
Oh, okay.
I'm not sure. She might be. I have no idea.
Well, okay.
Been there, done that. What's up, buddy? How we doing? Oh, you're sick, right? You got the vid or something? Hope it's a quick version. Hope it goes fast, and hopefully it doesn't hurt too bad.
How do you know this?
I was on a stream with him yesterday.
Oh, really? On what stream?
On Legal Vices. I was on the Very Mighty Christmas. Yes. AP, what's up, brother, man?
I have to go watch that.
How are we doing? Yeah, you should. Me and Flux and Danielle was there. Been there, done that.
I saw Danielle after you had already gone over to MLS, I think.
And then she was on Experts last night with me. You watched that.
Yeah.
Wolfkinder, what's up? How are you? Hopefully good. I hope. Hi, Elizabeth. Good to see you. Glad y'all are here. I guess for a quick recap, this is the Elijah McClain murder trial, number 3, actually. The first 2 were 2 police officers in one and 1 police officer in another. 2 of those police officers were acquitted. 1 was convicted. Now we are on to 2 paramedics that are on trial for the loss of this young man. Brief summary of the case is this. He was walking home. What's that?
I said hello, John. Sorry.
You're good. Hi, Sonny Tanner. Welcome. How we doing? From Florida. Nice. He was walking home from a convenience store. Somebody called in a suspicious person call on him. Police showed up and very quickly went hands-on. There was a struggle. He was choked unconscious. He vomited, then aspirated. Then the paramedics showed up and gave him an injection of ketamine, which seems to be making the news a lot recently, which is very strange to me, but we'll get into that later, possibly sometime. Something's happening there. Anyway, his heart and breathing stopped very shortly thereafter as they were putting him in the ambulance, or as he got into the ambulance, and he was DOA by the time he got to the hospital. They put him on tubes and machines for a couple days and was officially pronounced like 3 days later or something. So in this trial, the two paramedics are being charged with reckless manslaughter, negligent homicide, and a slew of assault charges.
Second-degree assaults.
There was a bunch of them though. There's like a drugging charge in there.
Yes.
There's a whole bunch of assault charges. And today is the final day. We've done all of the testimony. Today is we do what we want, MLS. We do what we want. There is a I just lost my train of thought. What the hell was I saying? Oh, we just wrapped up all of the testimony yesterday. Today we are going to do the jury instructions, closing statements, and the verdict, because the verdict came out in real life yesterday. So that's already out there.
Worst time to have a jury deciding your fate.
Friday before Christmas.
Friday before Christmas after an Allen charge.
Insane.
Like, that's not going to go well.
None of this went well. None of it. The whole case has been nuts. Outstanding. Which day? Which day? Because we got 2 January dates. Kids have to have the family party rescheduled. The bigger bummer is the kids have to have the family party rescheduled.
Oh, that stinks.
Ouch. Ouch.
That's not cool.
Well, that being said, let's get into. Oh, I still have to present this, don't I? Share screen. This one. Share. Let's put up the sheep. It's not a goat, y'all. It's a sheep. And that. And I believe I have it timed right before the jury comes in to receive jury instructions. So it's halfway through the video, as you can see, but we cut out all of the BS argument over the jury instructions because I can't deal with it. It was 4 hours of stupidity that I'm just to get to this point. So we're just going to go to this point. And hopefully that's okay with everybody, because if not, I don't care. This is what we did. I do what I want.
Here's a drink.
Oh. Let me know what date that she confirmed for, and I'll put it out there. Hello, Elizabeth again. We appreciate the support. Oh,
thank you.
Silly me, forgot to mention that I am streaming this as well as McKinley.
All right, our jurors have returned and are in the process of being seated.
The links are in the top of both of our chats. So if you would be so kind, run over to the other stream, wherever you're at, and hit that like button. Make sure you're subscribed to both.
21 CR 2800.
It is greatly appreciated.
21 CR 2806. Those are people of the state of Colorado v. Jeremy Cooper and people of the state of Colorado v. Peter Cichuniec. The parties and counsel are present. The jurors are present. Apologize for the delay. I wasn't anticipating that the copy machine would jam. But you all have copies of the jury instructions that I must read to you.
The copy machine jammed.
Yep.
And you will be able to take these jury instructions with you into the jury room when you deliberate.
He was anticipating it, though. Remember yesterday?
They've been having all kinds of copier issues, which is odd.
You must apply to reach your verdict. You will have copies of what I read to take with you to the jury room. But first, I want to mention a few
Kinko's
things
somewhere
you need to keep in
nearby.
mind when you are deliberating this case in the jury room. Until you have returned a verdict, you must not do any research about this case or this kind of case using any source, including dictionaries, reference materials, the internet, or any other electronic means. You must not communicate in any way with anyone else about this case or this kind of case until you have returned a verdict in court. This includes your family and friends. If you have cell phones or other electronic devices, you must keep the devices turned off during jury deliberations.
Thanks, Flashfan.
It is my job to decide what rules of law apply to the case. While the attorneys may comment on some of these rules, you must follow the instructions I give you. Even if you disagree or do not understand the reasons for some of the rules of law, you must follow them. No single instruction describes all the law which must be applied. The instructions must be considered together as a whole. During the trial, you received all of the evidence that you may properly consider in deciding the case. Your decision must be made by applying the rules of law that I give you to the evidence presented at trial. Remember, you must not be influenced by sympathy, bias, or prejudice in reaching your decision. If you decide the prosecution has proved beyond a reasonable doubt that Mr. Cichuniec and or Mr. Cooper is guilty, it will be my job to decide what the punishment will be.
Is that how you spell
In
it?
making your decision, you must not consider punishment at all.
CICHUNIEC.
Times during the trial, attorneys made objections. Do not draw any
That's how I've been.
conclusions from
That's
the
how.
objections or from
Yes.
rulings on
We've
the
been spelling it. Okay.
Yeah.
These only related to legal questions. I had to decide.
Us and
to
law
not
and
influence
crime.
your thinking. If I told you not to consider a particular statement that was made during the trial, you must not consider it in your deliberations. I have asked questions of witnesses during the trial. That did not mean that I had any opinion about the facts of the case. Finally, you should consider all the evidence in light of your experience in life. Number two, the charges against Peter Cichuniec and Jeremy Cooper are not evidence. The charges against Mr. Cichuniec and Mr. Cooper are just accusations. The fact that Mr. Cichuniec and Mr. Cooper have been accused is not evidence that either of them committed any crime. Peter Cichuniec and Jeremy Cooper are charged with committing the crimes of manslaughter reckless, August 24 to August 27, 2019, assault in the second degree with intent to cause bodily injury, causing serious bodily injury, August 24, 2019, and with assault in the second degree, unlawful administration of drugs, August 24, 2019, in Adams County, Colorado. The defendants have pleaded not guilty. 3. Every person charged with the crime is presumed innocent. This presumption of innocence remains with Mr. Cichuniec and Mr. Cooper throughout the trial and should be given effect by you unless, after considering all the evidence, you are convinced that Mr. Cichuniec or Mr. Cooper is guilty beyond a reasonable doubt. The burden of proof in this case is upon the prosecution. The prosecution must prove to the satisfaction of the jury beyond a reasonable doubt the existence of each and every element necessary to constitute the crime charged. This burden requires more than proof that something is highly probable, but it does not require proof with absolute certainty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If you are firmly convinced of Mr. Cichuniec's or Mr. Cooper's guilt, then the prosecution has proven the crime charged beyond a reasonable doubt. But if you think there's a real possibility that Mr. Cichuniec and or Mr. Cooper is not guilty, then the prosecution has failed to prove the crime charged beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has proven each of the elements of a crime charged beyond a reasonable doubt, you should find Mr. Cichuniec and or Mr. Cooper guilty of that crime. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the
Hello,
elements of the crime
Rose.
charged beyond a reasonable doubt,
Thank you for stopping by.
Mr. Cichuniec and or Mr. Cooper not
You're
guilty
amazing.
of that crime.
And
Number 4,
Merry Christmas.
you
babe.
are the sole judges of the credibility of each witness and the weight to be given to the witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each
I
witness
know
has
they're not
testified.
speaking this fast.
For each
I think
witness
It's sped up
sped
slightly.
like a
It's at-
lot.
It's at 1.25.
Consider the witness's ability to observe, the strength of
Now,
that
it might
person's
be
memory,
too hard
and
for
how that
these
person
jury
obtained
instructions
his
for
or
it
her
to be
knowledge.
sped up at all,
Consider any
honestly.
relationship that witness
That's
may
fair.
have with either
I
side
had
of
to
the
keep
case,
rewinding
and how
earlier
each
when I was
witness
trying to
might be
listen.
affected by the verdict.
We're at normal
Consider
speed
how
now.
the testimony
Okay.
of the witness
Whew.
is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You are not bound by the testimony of witnesses who have testified as experts.
And actually,
Their
I could
credibility,
probably move that over.
the
This way, so-
credibility rather of an expert's testimony is to be considered as that of any other witness. The weight you give an expert's testimony is entirely your decision. You may believe all of the testimony of a witness, part of it, or none of it. The number of witnesses testifying for or against a certain fact does not by itself prove or disprove that fact. 5, a fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on firsthand observation of the fact in question. Circumstantial evidence is indirect. It is based on observation of related facts that may lead you to reach a conclusion about the fact in question. Number 6, the court has taken judicial notice of a certain fact. You may or may not accept that fact as true. It is entirely your decision to determine what weight, if any, shall be given to the evidence. 7, in this case, separate offenses are charged against each of the defendants in each count of the indictment. Each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately, uninfluenced by your decision as to any other count. The fact that you may find Mr. Cichuniec or Mr. Cooper guilty or not guilty of one of the offenses charged should not control your verdict as to any other offenses charged against Mr. Cichuniec or Mr. Cooper. Mr. Cichuniec or Mr. Cooper may be found guilty or not guilty of any one or all of the offenses charged. In this case, you must decide separately whether each of the two defendants is guilty or not guilty. If you cannot agree upon a verdict as to both defendants, but do agree as to one of them, you must render a verdict as to the one upon which you do agree. It is your duty to give separate personal consideration to the case of each individual defendant. When you do so, you should analyze what evidence in the case shows with respect to that individual. Each defendant is entitled to have his case determined from evidence as to his own acts and culpable state of mind, and any other evidence in the case which may be applicable to him. You must state your finding as to each defendant uninfluenced by your verdict as to the other defendant. Number 8, the crime is committed when the defendant has committed a voluntary act prohibited by law together with a culpable state of mind. A voluntary act means an act performed consciously as a result of effort or determination. Proof of the voluntary act alone is insufficient to prove that the defendant had the required state of mind. The culpable state of mind is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt, either by direct or circumstantial evidence. In this case, the applicable states of mind are explained below. A person acts intentionally or with intent when his conscious objective is to cause the specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk that a result will occur or that a circumstance exists. A person acts with criminal negligence when, through a gross deviation from the standard of care that a reasonable person would exercise, he fails to perceive a substantial and unjustifiable risk that a result will occur or that a circumstance exists. Number 9, certain words and phrases have particular meaning. The following are definitions of these words and phrases. Administer means to apply a controlled substance, whether by injection, inhalation, ingestion, or any other means directly to the body of another. Bodily injury means physical pain, illness, or any impairment of physical or mental condition.
Oh, awesome,
Conduct
Sonny.
means an act or series of acts and its accompanying state of mind, or where relevant, a series of acts.
Awesome.
Drug means substances intended for use in the diagnosis, cure, mitigation, treatment, or prevention of disease in individuals intended to affect the structure or any function of the body of individuals. Serious bodily injury means injury which either at the time of the actual injury or at a later time after the actual injury involves a substantial risk of death or a substantial risk of protracted loss or impairment of the function of any part or organ of the body. Instruction number 10. Each defendant is charged with the crime of manslaughter or reckless. The elements of the crime of manslaughter are: 1, that the defendant; 2, in the state of Colorado, in the county of Adams, on or about August 24th, 2019, up through and including August 27th, 2019. 3, recklessly; 4, caused the death of Elijah McClain. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of manslaughter. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of manslaughter. 11, If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the offense charged, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt.
So lesser
The
included.
offense of manslaughter reckless is charged in
Right.
the indictment in this case necessarily includes the lesser offense of criminally negligent homicide. The elements of the crime of criminally negligent homicide are one, that the defendant, two, in the state of Colorado and the county of Adams, on or about August 24, 2019, up through and including August 27, 2019, caused the death of Elijah McClain, 4, by conduct amounting to criminal negligence. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser included offense that is necessarily included in the offense charged in the indictment. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide the prosecution has proven each of the elements of manslaughter reckless, you should find the defendant guilty of that offense and should so state in your verdict. After considering all the evidence, if you decide the prosecution has failed to prove one or more of the elements of manslaughter reckless, then you must decide whether a defendant is guilty or not guilty of criminally negligent homicide. After considering all the evidence, if you decide the prosecution has proven each of the elements of criminally negligent homicide, you should find the defendant guilty of that offense, and you should so state in your verdict. If you decide the prosecution has failed to prove one or more of the elements of criminally negligent homicide, you should find the defendant not guilty of that offense, and you should so state in your verdict. While you may find the defendant not guilty of both manslaughter reckless and criminally negligent homicide, you may not find the defendant guilty of more than one of the following offenses: reckless manslaughter or criminally negligent homicide.
I believe so, Sonny. I believe
Instruction
so.
number 12. The evidence presented in this case has raised the question of use of physical
Yes.
force in a special relationship with respect to manslaughter, reckless, and criminally negligent homicide. The defendant was legally authorized to use physical force upon another person if, 1, he was a duly licensed paramedic acting under the direction of a duly licensed physician, and 2, he used reasonable and appropriate physical force for the purpose of administering a recognized form of treatment that he reasonably believed
Everybody's
be
dropping
adapted
like flies.
to promoting the physical or mental health of the patient, and 3, the treatment was administered in an emergency when the duly licensed paramedic acting under the direction of a duly licensed physician reasonably believed that no one competent to consent could be consulted, and that a reasonable person wishing to safeguard the welfare,
So this is the
welfare,
affirmative
rather, of the
defense.
patient would consent. You have been instructed that the prosecution has the
What
burden of
is?
proving beyond a
What they
reasonable
just
doubt
said.
all of the elements of manslaughter, reckless, and criminally negligent homicide,
Like
including
for
that
the use of force, like forcefully injecting him. There is an affirmative defense to it, but like just based on what they say, the elements that they named, they clearly don't meet it because they could have asked him if he consented.
Right.
So,
Right. Okay. Maybe not. Well, what exactly is an affirmative defense?
An affirmative defense. An affirmative defense means that it's justification, right? So you can still meet all the elements of the crime, but you're justified legally in doing so if you meet all the elements of the affirmative defense, but it's on the defense to prove that they've met all the elements of that defense. And
a better example of this, or an easier example of this, if I'm not mistaken, is self-defense, right? Yes, I fired the firearm, I pulled the trigger, it ended that man's life, but I did it because he was attacking me and my life was in danger.
Bye, Flash fan. Yeah, totally.
Thanks,
But there
Mr.
are
James. Thanks.
But there are elements to that, to being able to use self-defense. You know, you have to meet the elements of the affirmative defense. Like you can't be the aggressor, like the initial aggressor, and you can depending on what jurisdiction you're in, you can only use as much force as is reasonably necessary to like.
Every state's got a different
criteria
for all of that.
Right.
Okay. Good. Thank you for explaining that a
You're
little
welcome.
bit.
Defendant acted recklessly or in a criminally
Thanks, Mr.
negligent
James.
manner.
Not my birthday though,
We're
buddy.
further instructed that
birthday.
with respect to manslaughter, reckless, and criminally negligent homicide, the prosecution does
Merry
not
Christmas,
have
Flash
an
Man.
additional burden to disprove the use of physical force, special relationship. You are instructed, though, that a person does not act recklessly or in a criminally negligent manner if his conduct is legally justified as set forth above. This instruction applies only to manslaughter, reckless, and criminally negligent homicide.
Bless you.
13.
Goodness.
Each defendant is charged with the crime of assault in the second degree, intent to cause bodily injury, causing serious bodily injury. The elements of the crime of assault in the second degree, intent to cause bodily injury, causing serious bodily injury are: 1, that the defendant, 2, in the state of Colorado and the county of Adams, on or about August 24, 2019. 3, with intent. 4, to cause bodily injury to Elijah McClain. 5, cause bodily injury to Elijah McClain. 6, and the defendant's conduct was not legally authorized by the affirmative defense in instruction 26. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of assault in the second degree, intent to cause bodily injury, causing serious bodily injury. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of assault in the second degree, intent to cause bodily injury, causing serious bodily injury. Each defendant is charged with the crime of assault in the second degree, unlawful administration of drugs. The elements of the crime of assault in the second degree, unlawful administrations of drugs are: 1, that the defendant, 2, in the state of Colorado and the county of Adams, on or about August 24, 2019. 3, intentionally. 4, for a purpose other than lawful medical or therapeutic treatment. 5, caused stupor, unconsciousness, or other physical or mental impairment or injury to Elijah McClain. 6, by administering a drug, substance, or preparation capable of producing the intended harm. 7, without that person's consent. 8, and that the defendant's conduct was not legally authorized by the affirmative defense in instruction 26. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of assault in the second degree, unlawful administration of drugs. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of assault in the second degree, unlawful administration of drugs. 15. The word cause as used in these instructions means an act or series of acts that in natural and probable sequence produced the claimed injury or death. It is a cause without which the claimed injury or death would not have happened. If more than one act or series of acts contributed to the claimed injury or death, then each act or series of acts may have been a cause of the injury or death.
Thank you, Eris.
A cause does not have to be the only cause or the last or nearest cause if the act or series of acts joins in a natural and probable way with some other act or series of acts to cause some or all of the claimed injury or death. 16.
I mean,
you may find
they're screwed
that Mr. Cichuniec and Mr.
I think
Cooper
so, yeah.
committed the charged offenses as a principal or as a complicitor or as both. Mr. Cichuniec and Mr. Cooper are alleged to be complicit in each other's actions, but not the actions of law enforcement. The following complicity liability instructions should be considered in this light. 17. For manslaughter, reckless, the defendant may be either a principal or a complicitor. Complicity is not a separate crime, rather it is a legal theory by which one person may be found guilty of a criminal offense that was committed by another person. For the defendant to be found guilty as a compliciter of the crime of manslaughter reckless as defined at the end of this instruction. The prosecution must prove each of the following conditions beyond a reasonable doubt. One, another person or persons
I forgot to send out links.
crime of manslaughter is defined at the end of this instruction. The defendant with the desire or purpose to aid, abet, advise, or encourage the other person or persons in the planning or committing that crime.
You're amazing.
Aided, abetted, advised, or encouraged the other person or persons in planning or committing that crime. 4, that the defendant was aware of elements 1, 2, and 3 of that crime as defined at the end of this instruction. For the purposes of this instruction, another person committed the crime of manslaughter reckless if the prosecution proves each of the following elements beyond a reasonable doubt. That the other person or persons, 2 in the state of Colorado and the county of Adams, on or about August 24, 2019 to August 27, 2019. 3, recklessly. 4, caused the death of Elijah McClain. After considering all the evidence, if you decide the prosecution has proven each of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant guilty of manslaughter reckless. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity beyond a reasonable doubt, you should find the defendant not guilty of manslaughter reckless.
Hey, BL Blazy, how we doing?
Prosecution alleges that Mr. Cichuniec or Mr. Cooper are each guilty of the crime of manslaughter reckless as a principal or as a complicitor. You have received separate instructions regarding these 2 theories of liability. Instruction 10 describes the principal theory of liability, and instruction 17 describes the complicity theory of liability. You should consider the 2 theories separately. Your determination of whether either defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether either defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability and complicity liability. Or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. 19. For criminally negligent homicide, a defendant may be either a principal.
I did get another wrench today. Shout out Crime Spies. Shout out Crime Spies.
Nice.
By which one person may be found guilty of a criminal offense that was committed by another person.
Hey, Wolfie, how you doing, buddy?
To be found guilty as a compliciter of the crime of criminally negligent homicide, as defined at the end of the instruction, the prosecution must prove the following conditions beyond a reasonable doubt. 1, another person or persons must have committed the crime of criminally negligent homicide as defined at the end of this instruction. And 2, the defendant with the desire or the purpose or design to aid, abet, advise, or encourage the other person or persons in planning or committing that crime. 3, aided, abetted, advised, or encouraged the other person or persons in planning or committing that crime. 4, the defendant was aware of elements 1, 2, and 4 of that crime as defined at the end of the instruction. Actually, it's 1, 2, 3, and 4. For purposes of this instruction, another person has committed the crime of criminally negligent homicide if the prosecution proves each of the following elements beyond a reasonable doubt. 1, that the other person or persons in the state of Colorado and the county of Adams on or about August 24, 2019 to August 27, 2019 caused the death of Elijah McClain. 4, by conduct amounting to criminal negligence. After considering all the evidence, if you decide the prosecution has proven each of the conditions of complicity beyond a reasonable doubt, you should find him guilty of criminally negligent homicide. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity beyond a reasonable doubt, you should find the defendant not guilty of criminally negligent homicide. 20, the prosecution alleges that Mr. Cichuniec or Mr. Cooper are each guilty of the crime of criminally negligent homicide as a principal or as a complicitor. You have received separate instructions regarding the 2 theories of liability. Instruction 11 describes the principal theory of liability, and Instruction 19 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether either defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether either defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability and complicity liability. Or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. 21. For assault in the second degree intent to cause bodily injury causing serious bodily injury, a defendant may be either a principal or a complicitor. Excuse me for a moment.
Yeah, he was struggling with that negligent word, wasn't he?
Complicity is not a separate crime, rather it is a legal theory by which one person may be found guilty of a criminal offense that was committed by another person. For the defendant to be found guilty as a complicitor of the crime of assault in the second degree intent to cause bodily injury causing serious bodily injury as defined at the end of this instruction, the prosecution must prove each of the following conditions beyond a reasonable doubt. 1, another person or persons must have committed the crime of assault in the second degree intent to cause bodily injury causing serious bodily injury. 2, the defendant with the desire or the purpose or design to aid, abet, advise, or encourage the other person or persons
I need to take a break. Hold on a second.
In planning or committing that crime, rather. 3, aided, abetted, advised, or encouraged the other person or persons in
I'm sure he's got water up there.
That crime.
Yeah, he barely takes a breath, though.
4, the defendant was aware of elements 1, 2, 3, 4, and 6 of that crime as defined at the end of this instruction. 5, and the defendant's conduct was not legally authorized by the affirmative defense in instruction 26. For the purposes of this instruction, another person committed the crime of assault in the second degree intent to cause bodily injury, causing serious bodily injury, if the prosecution proves each of the following elements beyond a reasonable doubt. 1, that the other person or persons in the state of Colorado, in the county of Adams, on or about August 24, 2019, with the intent 4, to cause bodily injury to Elijah McClain. 5, cause serious bodily injury to Elijah McClain.
Excuse me for a minute.
Okay. Uh-oh. Did he pause us?
And
No.
it's 21A.
They're still moving.
It follows. After considering all the evidence, if you decide the prosecution has proven each of the conditions of complicity beyond a reasonable doubt, you should find the defendant guilty of assault in the second degree, intent to cause bodily injury, causing serious bodily injury. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity beyond a reasonable doubt, you should find the defendant not guilty of assault in the second degree, intent to cause bodily injury, causing serious bodily injury. 22. The prosecution alleges that Mr. Cichuniec or Mr. Cooper are each guilty of the crime of assault in the second degree, intent to cause bodily injury, causing serious bodily injury, as a complicitor, as a principal or as a complicitor. You have received separate instructions regarding these two theories of liability. Instruction 13 describes the principal theory of liability, and instruction 21 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether either defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether either defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability, and complicity liability, or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. 23. For assault in the second degree, unlawful administration of drugs, a defendant may
Dang,
be
the courtroom's
either a
packed.
principal or a complicit. Complicity is not a separate crime, rather it is a legal theory by which one person may be found guilty
Packed.
of a criminal offense that was committed by another person. For the defendant to be found guilty as a complicitor to the crime of assault in the second
Seems to
degree,
be a bit
unlawful
segregated
administration
as
of
well.
drugs, is defined at the end of this instruction. The prosecution must prove each of the following conditions beyond a reasonable doubt. 1, another person or persons must
That's
have
crazy.
committed the crime of assault in the second degree, unlawful administration of drugs. 2, the defendant with the desire or the purpose or design to aid, abet, advise, encourage the other person or persons in planning or committing that crime. 3, aided, abetted, advised, or encouraged the other person or persons in planning or committing that crime. 4, the defendant was aware of elements 1, 2, 3, 4, 6, and 7 of that crime as defined at the end of this instruction. 5, and the defendant's conduct was not legally authorized by the affirmative defense in instruction 26. For the purposes of this instruction, another person committed the crime of assault in the second degree, unlawful administration of drugs, if the prosecution proves each of the following elements beyond a reasonable doubt. That the other person or persons, two in the state of Colorado and the county of Adams, on or about August 24, 2019. 3, intentionally for a purpose other than lawful medical or therapeutic treatment. 5, caused stupor, unconsciousness, or other physical or mental impairment or injury to Elijah McClain. 6, and this is 23A, the second page. By administering a drug, substance, or preparation capable of producing the intended harm. 7, without that person's consent. After considering all the evidence, we decide the prosecution has proven each of the conditions of complicity liability beyond a reasonable doubt. You should find the defendant guilty of assault in the second degree, unlawful administration of drugs. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the conditions of complicity liability beyond a reasonable doubt, you should find the defendant not guilty of assault in the second degree, unlawful administration of drugs. 24. Prosecution alleges that Mr. Cichuniec or Mr. Cooper are each guilty of the crime of assault in the second degree, unlawful administration of drugs as a principal or as a complicitory. You have received separate instructions regarding these two theories of liability. Instruction 14 describes the principal theory of liability, and instruction 23 describes the complicity theory of liability. You should consider the two theories separately. Your determination of whether either defendant is guilty of the above referenced crime as a principal should not affect your determination of whether the defendant is guilty of the above referenced crime as a complicitor. Similarly, your determination of whether either defendant is guilty of the above referenced crime as a complicitor should not affect your determination of whether the defendant is guilty of the above referenced crime as a principal. You may find the defendant not guilty of the above referenced crime under both theories of liability, principal liability, and complicity liability. Or you may find the defendant guilty of the above referenced crime as a principal, as a complicitor, or as both a principal and a complicitor. 25. If you find the defendant not guilty of assault in the second degree, unlawful administration of drugs, you should disregard this instruction and sign the verdict form to indicate your not guilty verdict. If, however, you find the defendant guilty of assault in the second degree, unlawful administration of drugs, whether as a principal or as a complictor or both, you should sign the verdict form to indicate your finding of guilt and answer the following question on the verdict form. Did the defendant and or the principal cause serious bodily injury or death? The answer would be yes or no. The defendant and or the principal cause serious bodily injury or death only if, 1, the defendant and or principal cause serious bodily injury or death to any person except another participant. 2, during the commission of assault in the second degree, unlawful administration of drugs. The prosecution has the burden of proof rather a burden to prove each numbered condition above beyond a reasonable doubt. After considering the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line on the verdict form after considering all the evidence. If you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line on the verdict form. 26. The evidence presented in this case has raised the affirmative defense of use of physical force in a special relationship. With respect to assault in the second degree, intent cause bodily injury causing serious bodily injury, and assault in the second degree, unlawful administrations of drugs, the defendant was legally authorized to use physical force upon another person if, 1, he was a duly licensed paramedic acting under direction of a duly licensed physician,
Yes,
and
it is
2,
closing.
Well,
use
technically, this is jury
reasonable and
instruction.
appropriate physical force
right.
for the purpose
Closing
of
will come after
Gearing up
this.
a
for closing
recognized form
argument.
of treatment that he reasonably
Technically.
believed to be adapted
Yeah, you're
to
right.
promoting the physical or mental health of the patient, and 3, the treatment was administered in an emergency when the duly licensed paramedic acting under the direction of a duly licensed physician reasonably believed that no one competent to consent could be consulted and that a reasonable person wishing to safeguard the welfare of the patient would consent. The prosecution has the burden to prove beyond a reasonable doubt that the defendant's conduct was not legally authorized by this defense. In order to meet this burden of proof, the prosecution must disprove beyond a reasonable doubt at least one of the above numbered conditions. After considering all the evidence, if you decide the prosecution has failed to meet this burden of proof, then the prosecution has failed to prove the defendant's conduct was not legally authorized by this defense, which is an essential element of assault in the second degree, intent to cause bodily injury, causing serious bodily injury, and assault in the second degree, unlawful administration of drugs. In that event, you must return a verdict of not
MLS is
guilty
streaming right
of
now.
those offenses. After
Could be.
considering all the evidence, if you decide the prosecution has met
He's
this burden
law
of proof,
splaining.
then the prosecution has proved the defendant's conduct was not legally authorized by this defense. In that event, your verdicts concerning the charges of assault in the second degree, intent to cause bodily injury, causing serious bodily injury, and assault in the second degree, unlawful administration of drugs, must
That's
depend
why
upon
he's
your
not
determination
here.
whether the prosecution has met its burden of proof with respect to the remaining elements of those offenses. 27. Members of the jury, you may discuss this case only when you are all present, and you may only deliberate in the jury room. No juror should attempt to discuss this case with other jurors or anyone else at any other
Oh,
time
nice.
except when all jurors are in the jury room. 28. If there has been any news coverage of this case or any related information, you must completely disregard it. Your decision in this case must be based solely on the evidence presented at the trial. 29, once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to the court's judicial assistant, who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that, under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and verdict forms at the end of the case. 30. At the conclusion of closing
I'll be right
argument,
back.
the court's
Okay.
judicial assistant will escort you to the jury room, where you will select one of your members to be your foreperson. Your foreperson will preside over your deliberations and shall sign any verdict form that you may agree on according to the rules I'm about to explain. The verdict for each charge must represent the considered judgment of each juror, and it must be unanimous. In other words, all of you must agree to all parts of it. Only one verdict shall be returned, signed for each count for each defendant. The verdict forms and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching a verdict, you will inform the court's judicial assistant, who will in turn notify me, and you'll remain in the jury room until I call you into the courtroom. You will be provided with 6 verdict forms. When you have unanimously agreed upon your verdicts, you will select the option on each form which reflects your verdict, and the foreperson will sign the verdict forms as I've stated. I will now read you the verdict forms. You must not draw any inferences based upon the order in which I read them. Verdict forms will read as follows. People of the state of Colorado v. Jeremy Cooper, jury verdict, charge of manslaughter reckless. We, the jury, find the defendant Jeremy Cooper not guilty of manslaughter reckless and the lesser included offense of criminally negligent homicide. Beneath that, there's a signature line for the foreperson. Roman 2, we the jury find the defendant Jeremy Cooper of, and there's 2 boxes beneath that, manslaughter, reckless, or criminally negligent homicide. There's further direction. It says if you find the defendant not guilty of the charged offense and the lesser included offense, the foreperson should sign only section 1 above. If you find the defendant guilty of the crime charged or the lesser included offense, the foreperson should complete only this guilty verdict by placing in ink an X in the appropriate square. Only 1 square may be filled in with the other, with the remainder to remain unmarked. The foreperson will then sign only section 2 above. Next verdict form, this reads the same. People of the state of Colorado v. Jeremy Cooper, charge of assault in the second degree, intent to cause bodily injury, causing serious bodily injury. Roman 1, we the defendant find the defendant Jeremy Cooper not guilty of assault in the second degree, intent to cause bodily injury, causing serious bodily injury. Beneath that, there's a signature line for the foreperson. Roman 2, we the jury find the defendant Jeremy Cooper guilty of assault in the second degree, intent to cause bodily injury, causing serious bodily injury, with signature line for the foreperson. Once again, it explains you may sign only Roman 1 or Roman 2 above. 1 if the verdict is not guilty, 2 if the verdict is guilty.
I've never heard it read like that. Roman 2. Interesting.
Next, again, is people of the state of Colorado v. Jeremy Cooper. Jury verdict, charge of assault in the second degree, unlawful administrations of drugs. Roman 1, we the jury find the defendant Jeremy Cooper not guilty of assault in the second degree, unlawful administration of drugs. Signature line for the foreperson. Beneath that, Roman 2, we the jury find the defendant Jeremy Cooper guilty of assault in the second degree, unlawful administration of drugs. Beneath that is a signature line for the person. Beneath that, we further find with respect to the verdict question for this count as follows. The question is, did the defendant and or the principal cause bodily injury or death? And then there's 2 boxes, yes or no. And again, once again, they all read, Roman 1 needs to be signed if the verdict is not guilty. Roman 1 if not guilty, Roman 2 if the verdict is guilty. If the verdict is guilty, then you must mark the answer you find on the question below. All right, now we're to people of the state of Colorado v. Peter Cichuniec. Roman, and this is for reckless manslaughter. We, the jury, find the defendant Peter Cichuniec not guilty of manslaughter, reckless, and the lesser included offense of criminally negligent homicide. Beneath that is a signature line for the foreperson. Beneath that is Roman 2, we, the jury, find the defendant Peter Cichuniec guilty of reckless manslaughter, or beneath that, criminally negligent homicide. As explained in the other instructions, Roman 1 would be where the foreperson signs if the verdict is not guilty. Roman 2, if the verdict is guilty, then you may only select 1 of the boxes, either reckless manslaughter or criminally negligent homicide, if it is a guilty verdict. People of the state of Colorado v. Peter Cichuniec, assault in the second degree, intent to cause bodily injury, causing serious bodily injury. Again, Roman 1 reads, we, the jury, find the defendant Peter Cichuniec not guilty of assault in the second degree with intent to cause bodily injury, causing serious bodily injury, with the signature line for the foreperson. Roman 2, we, the jury, find the defendant Peter Cichuniec guilty of assault in the second degree with intent to cause bodily injury, causing serious bodily injury, with the signature line. Once again, it explains only 1 above may be signed, 1 if not guilty, and Roman 2 if the verdict is guilty. Finally, people of the state of Colorado v. Peter Cichuniec, jury verdict, charge of assault in the second degree, unlawful administration of drugs. Roman 1, we, the jury, find the defendant Peter Cichuniec not guilty of assault in the second degree, unlawful administration of drugs, with the signature line for the foreperson. Roman 2, we, the jury, find the defendant Peter Cichuniec guilty of assault in the second degree, unlawful administration of drugs. And again, there's a signature line for the foreperson. Only 1 can be signed, 1 if not guilty, 2 if guilty, and beneath that is the question. We further find, and that's if there is a guilty verdict, we further find with respect to the verdict question for this count as follows. The question is, did the defendant and or the principal cause serious bodily injury or death? And then there's a yes or a no. Beneath that is signature line for the foreperson. With that, we'll start the closing argument of counsel.
Oh, good. I like her voice, actually.
Her mic's not on, so it doesn't matter. Jumping straight into closing, huh?
Yeah.
Good deal.
Defendant Cooper and defendant Cichuniec made a plan. Here was the plan. We're going to leave that person on the ground. We're not going to speak to him. Not a single word. We're not going to
I
touch
don't know
him,
about that.
not with a single finger. We're not going to get a single piece of equipment out of our bag to assess him.
I didn't speak to
We're
him.
not going to put
I
our
don't think
faces
they like conspired
his
on the
face.
plan beforehand.
Well, no.
We're not going to ask one question about what happened to him. We're not going to listen to what he is trying to
The
say
plan.
to us.
That part, yeah, I got to know.
We're just going to wait for the ambulance.
The facts are kind of right.
while
just
we
the-
wait,
the
We aren't going to
but
do
I
a
don't think
single
it was a
one of those
plan.
things.
I don't either.
When the ambulance gets here, we're going to give him the maximum amount of ketamine that we're allowed to give. And we're going to give it to him whether he needs it or not. And then we're going to leave him on the ground.
The stretch, lady.
And once
That's
he
a
is
stretch.
completely lifeless, we'll pick him up and we'll move him to the gurney,
Stretch.
where we will continue to ignore his airway, his breathing, his circulation. And then we'll leave him at the hospital, where he won't be our problem anymore.
Where they're supposed to leave him.
And we'll still have no idea who he
This
is.
is so
or why we
disingenuous.
were even
It is a
called
little
to
bit.
help.
She could have done this way different.
That was the plan.
Way different.
The defendants that night made
That's
decision
like offensive.
after decision after decision. And every single one of those decisions ignored the risks to Elijah McClain. I'm going to
And
walk you through
wait, pause it for
the
1
evidence
second.
about what those decisions were.
I'm not going to do this the whole way through. I
You're
promise.
fine. You're
But
fine.
do you remember when the paramedics, one of them was on the stand, I think it was Cooper, and he tried to start talking about how he had stayed at the they had stayed at the hospital afterwards because they were worried about Elijah and they wanted to see what happened. And the prosecutors kept objecting, didn't want them to be able to get into that. And now she's saying they just left him and made it the hospital's problem. Like, that's such bullshit.
Hi, Lady Law. Welcome.
Hi, Lady Law.
I
Okay.
think I think that let's let her finish a little bit, but I don't like how she's starting this.
Yeah, it's irritating.
Yeah. She
And
could
the
have gotten
terrific
these facts
risks that
out
the
without
defendants
it
piled
being a
and
major
piled and
conspiracy.
piled on Elijah McClain until they killed him. It was that first decision, not to do an assessment at all. Within less than a minute of the time the defendants arrive on the scene, Defendant Cooper announces what he's going to do. We'll just leave him there until the
Get wrecked,
ambulance
Wrigley.
gets there.
Well, we'll just leave him. You've already been told several times to stop.
I can't sense myself. Ow.
Just leave him there until the ambulance gets here, and we'll just put him down to the green.
I think almost every witness in this case agreed that doing a good assessment is the fundamental basis for making any good medical decision. We heard over and over again that it includes getting information from the people on the scene, talking to your patient. Remember, how can I help you? What can I do for you today? And then doing a good physical exam. You talk to your patient so you can understand what their complaints are. You can understand if they're oriented. You can understand how they're doing. You do that physical exam, you check their ABCs, you check their vital signs. You can learn so much from listening to a patient breathe, from feeling their pulse, from touching their skin. The defendants didn't do single one of these things. And this assessment, this is what's specifically called for by the very protocol they were going under. Those first three boxes, they all require that the paramedic try to figure out what is going on with the patient. It tells you to try to address the patient's concerns, figure out if they've got a medical cause of what's going on with them, and then try to fix that. And that's exactly what the defendants were trained about ketamine and excited delirium. Excited delirium can have mimics. Lots of different things have similar symptoms. They were supposed to think about that. Think about what symptoms this patient actually had and try to treat them. They didn't do any of that. At the beginning of this case, I showed you this slide, and I told you that the evidence would show that the defendants failed to do every single one of these things. Didn't tell Elijah who they were, didn't try to identify him, didn't try to get his consent, didn't ask the police a question about it, didn't speak a single word to him, didn't get a piece of equipment out of the bag, didn't kneel down to look at him, didn't lean over to look at him, didn't put a single finger on him, didn't take a single vital sign. And now you've seen the evidence. Every single witness that was there that night that you heard testify, Mr. DeJesus, Mr. Bradley, Mr. Walker, Ms. Gonzalez, Sergeant Leonard, Officer Ward, every single one of them confirmed that not one of these things happened. And of course, you guys have watched it all on the body-worn camera. We also know that the defendants were supposed to gather information from the police about what had happened. And we watched Sergeant Leonard try over and over to tell them what happened. We put him into a carotid hold twice. He went out. He's been vomiting. And it's like they put on earmuffs and didn't even want to hear that information. Here's Defendant Cichuniec admitting they had no idea what was happening at that scene.
Whose responsibility is it to gain any more information at that time? Is it yours or who provided the most information, or how did you get any more information when you got there?
Try to find out who primary is on the PD side, speak to them.
And did you speak to someone at that time?
No, it was just general, a couple of people, and I don't know which officers they were.
Okay. And general information, what did you receive? Any more updated information at that time?
Nothing that we couldn't see.
There it is again.
Did officers tell you anything to that
Hi,
effect?
ma'am.
That
Welcome.
he was displaying excited delirium behavior or anything of that nature?
Not that I recall.
Okay. Did the officers explain to you anything that had been done to the person on the ground? Did they at any time tell you he had
Lord
used any
Farnham.
type of arrest control or force to detain him?
No.
Okay.
They knew nothing. They learned nothing. They asked no questions. They didn't care.
Hey, Lord Bynum. How you doing?
Let's talk
buddy?
about the excuses that you've heard from the defendants as to how they failed this requirement so egregiously. And when you think about these excuses, I need you to bring some very basic tools to that, your eyeballs and your common sense. First, we heard them say, oh, well, a visual assessment was fine, that we just needed to look at him and that would be sufficient. And you saw some experts sit up here and look over at the lawyer at the podium and say, see, I can visually assess you. I can see your breathing. I can see you have a pulse. You're standing up and you're talking. But Elijah wasn't standing up at a podium talking. He was down on the ground. He was gasping and gurgling. He was pleading for help. A visual assessment was not enough. The next excuse they had is that they wanted to do a better assessment, but Elijah was too aggressive, or the police were too aggressive, or they worried somebody was going to get agitated, or they were trying to de-escalate the police. This is where you're going to have to watch the video and use your common sense. Elijah is barely moving while the paramedics are there, maybe wiggling at the very most. He's not too aggressive to do an assessment of. And you're going to have to watch the video too and make your judgment about how these defendants felt about the police. Were they really too intimidated to do anything? They sure looked comfortable when they came in to give that ketamine, telling everybody what to do. Comfortable. That's how I think they looked at that scene. Here was another excuse that we heard. Defendant Cichuniec told you on Monday that they couldn't assess Elijah because he wasn't their patient until
Your
he was
mic did
out.
something weird.
What? They could inject him with ketamine when he wasn't their patient, but they couldn't get down and take his pulse? Again, folks, you're going to have to bring your common sense to think about these arguments.
It switched to my somehow.
What were the risks of not assessing Elijah? I think we heard it best from Dr. Buther. He said that giving a drug is like hitting the gas when you can't see out of your windshield if you haven't done an assessment of your patient. And you heard the same thing from Mr. Ludwig, the defendant's expert. Got up there and said, you have to bat 1,000 when you do a patient assessment, because if you don't treat the right thing, you're not going to help your patient. There was so much time to do this here. So much time to give Elijah the assessment that he was entitled to. So what is the risk of not assessing your patient? You're giving them the wrong treatment. And what happened? They made their next decision. Give ketamine. Within 2 minutes of arriving at the scene and having done nothing but barely look at Elijah, Mr. Cooper announces his plan again. When the ambulance gets here, we're going to go ahead and give him some ketamine. And what was the defendant's excuse for giving ketamine to someone who was already being easily restrained by the police? Well, there was only one excuse that they could give, and that's that he had excited delirium, because that's the only thing that would justify them giving ketamine. It was the only thing they were allowed to give ketamine for. But Elijah didn't have excited
Thank you,
delirium.
Harris.
He wasn't truly out of control. You saw the videos from the training and what those types of patients look like. He was responding to the police. He was crying out in pain. He was apologizing. The police actually don't look like they're struggling to control him at all. And the defendants don't observe a single symptom that's on this list while they're there. Disorientation, paranoia, hallucinations, they never speak to or hear one word that Elijah has spoken. So they couldn't possibly think that he has any of these symptoms. Tachycardia, hyperthermia, if you want to find out that those symptoms exist, you have to actually touch your patient. And they don't do either one of, find out either one of those things. Not once. And then there's increased strength. Before Defendant Cooper announces his plan to give the ketamine, no one said anything about increased strength. Elijah's being restrained on the ground easily. But after he says ketamine, then the police jump in. Oh, he did a push-up with this on his back. Oh, he was crazy strong. They never see one piece of evidence of that with their own eyes, and they never hear anything about it until after they made the decision to give ketamine. And what was the risk of giving ketamine without having done an assessment? Well, one of the risks is that if you're treating the wrong thing, you're not treating the right thing. You heard from expert after expert that Elijah was having acidosis, hypoxia, that he had aspirated vomit into his lungs, and that all he needed to treat that was oxygen and fluids. Even the defendant's expert, Dr. Dragovich, told you that. But the paramedics didn't do that because they were determined to give ketamine, and they didn't give him those basic life-saving measures that would have been so easy to give. So they haven't assessed their patient. They've chosen the wrong treatment, and now they've missed the right treatment. And what do they do next? The next decision? Let's max out that ketamine dose. Defendants were taught over and over again that ketamine was a weight-based drug. You do not deviate
I
from that.
don't know.
It's in the ketamine protocol. That's Exhibit 225.
I'm not sure.
And it was in their training repeatedly. 5 milligrams per kilogram. That's the dose of ketamine that you give. And you know, we've shown it. They've told over and over again, 500 milligrams is not for everybody, is not a good practice. Defendant Cichuniec, he admits he knew he wasn't supposed to give 500. Even under his inflated weight estimate, the maximum he should have given was 425. But he said, I don't want to pick up the phone and have to call for more, because that's what you have to do if you want to give a second dose. So what did he do? He just went ahead outside the protocol and gave the wrong dose. And we've heard some excuses about this too. Well, it's really hard to estimate somebody's weight. These guys didn't even try. They were going to give 500. They didn't care how much he weighed. All the things you could have done to check on somebody's weight,
I think
ask
that's
them,
probably true.
ask other people what they thought they
Mhm.
weighed, check in with your
I
partner.
think they were going to.
They didn't do any of that. They went straight to
Because it
500.
was easiest.
We also heard that they had to give 500 because you couldn't give less than that with the syringe that they had.
Bullshit.
This is another one where you just have to use your common sense. Of course they could have given a lower dose. Of course they could have given the right dose. And then another thing that I expect you'll hear, well, they thought ketamine was safe. But again, your common sense will tell you that if you were told to give a weight-based
What's
dose
up, buddy?
for a controlled substance that's kept
How you
under lock
doing?
and key, you don't just decide to give more. And the safety margin that you heard Dr. Hill talking about yesterday, generally ketamine is safe. And what did he say? He said it's safe in that 3 to 5 milligram per kilogram range. And he said, I've even heard sometimes where they're allowed to give 6 milligrams per kilogram. But remember how much Elijah got, 7.7 milligrams per kilogram, outside of even Dr. Hill's wide safety margin.
So here's the thing
And
that
the defendants knew.
here's what I'm struggling with, right? And we're all right. Everybody in chat's right. I don't believe this was malicious. She's being a drama mama. There wasn't a plan. The fact of the matter is, though, they're not charged with anything that is a malicious intent or a first degree, right? They're charged with reckless or negligence. And I think that if she were to focus on that more than the plan aspect of this closing would go so much smoother, in my opinion.
Yeah, I mean, it would just be a lot more credible because
Right.
it's hard to.
Right.
She kind of loses credibility with the jury in trying to paint them as having a malicious conspiracy.
They're not charged with that. There's no reason for her to
Right.
do it. It just
She
makes
does
her
not need
sound. It just makes her sound like a cat lady, in my personal opinion.
Yeah.
The risks of giving an overdose of ketamine. This is what they were taught. Respiratory drive should be preserved with appropriate dosing, but large doses increase the likelihood of adverse effects, and specifically respiratory depression. And the defendants admit they knew about that specific risk. And the experts confirmed it. Even defendants expert Dr. Hurd, he admitted it's true. If the more ketamine you give, the higher the risks of respiratory depression. And Dr. Robinson said it as well. When you give a higher dose, does that mean there's more opportunity for respiratory depression in the patient? Yes, it's a higher risk. There will be a respiratory compromise or depression. And again, even the defendants admit that they knew. In fact, Defendant Cooper, this was the only risk that he knew about when he was interviewed by the police. So they failed to assess. They decided to give the wrong thing. They decided to give the maximum dose of the wrong thing, even though they know that it carries a risk of respiratory depression. Elijah is deteriorating in front of their eyes at this point, but they are not changing their plan. You can look at him and see that he has no need for ketamine. They're going to give it anyway. You heard a lot of witnesses talk about why you give ketamine to somebody who has excited delirium. It's because they're struggling so much, they're so out of control that they're going to keep building up that lactic acidosis and they're not going to stop. Elijah is on the ground, barely moving. He does not need to have struggling minimized. He's not truly out of control.
You mean soccer, right?
You'll remember what he looks like in this time while they're waiting on the guy.
We haven't even got that far yet, man.
What?
It's a video she's playing.
But what'd you say about soccer?
Oh, to Orc said football. He means soccer.
No, I'm good. I'm just going to pat him down, make sure he doesn't have anything. We haven't got to that far yet.
Our experts told
Oh, it
you
won't be jail time. It will be
medical
prison.
purpose for him to get ketamine
If
at
they
this
get,
point.
yeah, if they
You heard
get
it from Dr. Buther,
convicted,
and you
it'll
heard it from
definitely
Dr.
be
Mitchell.
prison, not jail.
No
Well,
medical.
It could be probation, but for some of the offenses that are listed, it's like very uncommon to only have probation. Like the second degree assault charges, apparently, like almost all of the time come with a prison sentence.
Generally speaking, more than a year sentence is going to send you to prison and not jail. If it's like a year or less, you may be able to serve it in the county jail instead of the prison, but it kind of depends.
In Texas, we have like this thing called state jail also. So that's like from it goes up to 2 years, but that's just like this weird state jail. There's only one level of offense that goes there, and then everything else is either prison or regular county jail.
Oh, that's crazy.
Yeah, it's weird.
And what is the excuse that the defendants offer here? They say, well, we couldn't deviate from our protocol. Once we had decided to go down this protocol, we had to give ketamine. We had no choice. That's not true. The experts told you otherwise. Mr. Chambers and Dr. Hill said, no, if you're on a protocol and your condition of your patient changes, then you change what you're doing. You're not a robot. These are trained professionals with judgment to exercise. And of course, you don't sedate somebody who is barely moving. And what were the risks of giving ketamine to somebody who was barely moving? You're now increasing the risk of respiratory depression in a highly compromised patient. This is a person who is really sick, and now you're about to give them a drug that causes respiratory depression. And what's the next decision they make after that? Leave him prone, drowning in his own vomit, unable to protect his airway. You hear Defendant Cooper after he gives that injection to Elijah, who's laying there not moving. What does he say? We'll just give that a minute or two. Just leave him there. And the witnesses?
Just rub it right behind his ear if he fights, all right?
We'll give that a minute or two, see if that works, and once it is, we'll go ahead, if you guys are okay with it, we'll uncuff him, we'll go up with the right arm, down with the left, and we'll straighten everything. We'll give that a minute or two.
All right.
And the witnesses who were right there that night, they all confirm Elijah was left there prone, face down, unable to protect his airway after he got that injection, unable to clear the vomit from his lungs, unable to get the oxygen that he needed. Elisa Gonzalez confirmed the same thing. Did you see Mr. Cooper and Mr. Cichuniec approach the patient and address the fact that he was prone on the grass? No. All of this in direct contradiction of their training. They know not to leave people prone when they're sedated. And what was the risk of that? The risk of leaving him in that position? Can't protect his airway, can't get oxygen, can't clear his lungs. And what do they decide to do next? To ignore Elijah while he's dying. At this point, there is still a chance to save Elijah, but time is running out fast. You can hear how people, various witnesses, described how he looked at that time. Dr. Sina said, I'd call it agonal breathing, kind of breathing you do right before you die. Dr. Mitchell said, we know he is at risk of dying at this point. Dr. Buther said, we see him not breathing well at all and completely unresponsive. Elisa Gonzalez answered, was the patient doing anything, any movement? No. And even Dr. Sundaram said he goes flaccid completely. Where are the defendants? They aren't even paying attention. And that vomit is pouring out of Elijah's face. They're off, not even looking. And then he takes those two
What's up, Matt?
terrible
How we doing, buddy?
breaths. And where are the defendants? Oh, there's Mr. Cooper. And there's Mr. Cichuniec typing on his tablet, completely ignoring their patient. And once again, the defendants knew these risks. They knew the risk of respiratory depression. They knew the risk of keeping him prone. And even in non-sedated patients, they are told if you have somebody in restraints, it is mandatory that you are continuously monitoring their airway, breathing, and circulation. They didn't do it. 6 minutes goes by from the time they give that ketamine injection until the first time anyone tries to take Elijah's pulse, when it is absent. What are the defendant's excuses for this? Well, the protocol doesn't say we have to start monitoring right away. But this protocol that they were operating under assumes that you've just given ketamine to someone who has been out of control, not someone who already wasn't moving. And you heard Dr. Hill the other day. What did he say? He said, you should start monitoring as soon as you reasonably can. They didn't even have the equipment there. They left it all in the truck, and they weren't even looking at their patient to monitor him. They had a chance here to try to remedy all of the bad decisions that they had made up to that point, all of the risks that they had ignored. And instead, they just stroll down to the ambulance while Elijah dies. What were the risks of that? When somebody's gone into respiratory arrest, they are losing oxygen to their brain every second. Every second counts. Dr. Buther told you it could be a matter of just a minute or two, and a heart can stop. And that's what happened to Elijah. These are the decisions that the defendants made. These are the risks that they chose to put on Elijah McClain. I'm going to talk to you now about how all of that conduct relates to the jury instructions that you just received and the crimes that have been charged. The first crime that is charged is reckless manslaughter. And what that means is that the defendants recklessly caused the death of Elijah McClain. And recklessly means that there is a conscious disregard, the defendants consciously disregard a substantial and unjustifiable risk. You have seen this chart of all of the disregard they have made of all of these risks. Decision after decision after decision. And they knew the risks of every single one of those. Were those risks substantial? They were life-threatening. Of course they were substantial. Were those risks unjustified? Entirely. There was not one reason that the defendants
Not sure, but it was 2 days, I think.
Decisions.
I think it was 2 days.
There was no justification not to assess Mr. McClain. There was no justification to give someone who is not moving a sedative.
They can't get it right.
There is no justification
So who knows?
to ignore a lifeless patient for 6 minutes.
I heard this one lady say it didn't take long at all. So it means they all decided right away.
Beyond a reasonable doubt.
And there was definitely an Allen charge.
You're going to also hear about the crime of criminally negligent homicide.
What's an Allen charge again?
If you don't,
it's like when you can't decide, when they say they're like hopelessly deadlocked and they come and they tell the judge and the judge says, oh yeah, well, I'm going to read you this thing that says that you need to go back and consider everything and keep considering and keep discussing it. And basically until you come to a conclusion, like I'm not letting you out of here, you know?
So there's some of them that they didn't get resolved?
No, they ended up coming back after the Allen charge.
Okay. So the Allen charge was just the judge making them go back, essentially.
Yeah, the judge just saying, hey, no, I'm going to make you keep, deliberating on this on a Friday night before Christmas. And these people were like, I want to go home.
That's rough.
Has risen to the level for reckless manslaughter. And you can consider this charge. And it's simply a lower level of a mental state. It says that there has been a gross deviation from the standard of care that a reasonable person would exercise. He fails to.
We're doing it today, buddy. We're going all the way through the verdict today.
The defendants consciously disregarded these substantial and unjustifiable risks. They certainly also met this criteria for criminally negligent homicide. We also have to show that the defendant's actions caused the death of Elijah McClain. And importantly here, a cause does not have to be the only cause or the last cause or the nearest cause. It just has to be a cause. This is another situation where you can bring your common sense. You've seen the video. You've seen Elijah laying there, laboring to breathe. He gets the ketamine, and within minutes, he is going into respiratory and cardiac arrest and dies. But we've also given you lots of experts to explain how this happened. You'll remember from the beginning of the trial when we talked about the things that were happening. Elijah was in respiratory distress. He got the ketamine overdose. He was abandoned in that prone position, and all of those things led together to his respiratory arrest and his cardiac arrest. You heard from 4 different experts, all who confirmed that ketamine was the cause of Elijah's death. Dr. Sina, the independent pathologist who happened to do Elijah's autopsy, what was his conclusion? Complications of ketamine administration. You heard from Damon Robinson, an anesthesiologist, David Buther, a pulmonary and critical care doctor, and Roger Mitchell, another forensic pathologist, who all confirmed it was the ketamine that killed Elijah. Dr. Buther testified that it was the respiratory arrest caused by the ketamine that led to Elijah's death. And Dr. Robinson,
Oh, yeah.
same thing. Is it predictable based on
Like
the
and
high dose of
share,
ketamine that he received from
everybody.
the paramedics that he would suffer these injuries? Yes.
Yeah, make sure you hit the like button for both
And
of
in
us,
addition
please.
to these 4 experts, several others all also concluded that Elijah's heart had nothing to do with his death. Dr. Moss, his treating physician at the hospital, didn't think that his heart had anything to do with his death. And even the defense expert, Dr. Dragovich, he didn't think that the heart had anything to do with his death. His opinion was that Elijah died because of the aspiration. All of them agree his heart was not involved in his death. Now, you heard from one expert, Dr. Sundaram, who came in, and he didn't say the heart caused his death, but he said it might have had a role. And Dr. Sundaram talked about the theory of Occam's razor. This is the theory that the simplest explanation is usually the right one. And ironically, Dr. Sundaram seemed to think that his theory was the simplest one when it involved the notion that Elijah had died of a very rare coronary condition for which there was no actual evidence and no physical findings and no test that could reveal it. That he had had this incredibly rare coronary event right after the police had attacked him.
At least
Well,
one of the
what's
many
the other
experts they
explanation for
had
what
said
happened here?
that it was the cause.
Well, Elijah was put into a carotid
Can
hole
I
by the
fast
police.
forward
He
you?
threw up into his mask. We know that because
Nope.
we have the mask.
Now you're
His
stuck
lungs
with
were
us,
full
buddy.
of vomit. We know that too because we know it from the autopsy.
I thought he was.
You watch him steadily decline after
streaming.
that happens. And then he's given an overdose of a drug that's known to cause respiratory depression. And within
Nicholas
minutes,
is
he goes
streaming
into
on his
respiratory and
channel.
cardiac arrest.
Oh.
Which of these explanations is the simplest? Dr. Sundaram had a number of problems with his opinion, but at a basic level, it just doesn't make any common sense. And no one else agreed with him. You have many instructions in your packet about complicity. This simply means that you can be responsible if you don't do every part of the crime. You can be responsible as the principal who does the crime, or as a complicitor. Complicitor is just somebody who aids, abets, or encourages the crime. The defendants here, they both did all of these things together. You heard them say, you heard their experts say, they were acting as a team. They both decided to give the ketamine. They both decided to give 500. They both stood there while Elijah got worse and worse and did nothing. They are both responsible.
What's up, Dorothy? How you doing,
The
buddy?
defendants are also charged with assault with intent to cause bodily injury, causing serious bodily injury. Now, here's what a bodily injury simply means, or a number of things, but impairment of mental condition. And here, of course, the defendants intended to impair Elijah's mental condition. That's the whole reason why they said they gave him the ketamine, was to sedate him. And it's important to understand, it doesn't mean that they have to intend to impair his mental condition for the purpose of hurting him. It just means that they had to intend to impair his mental condition. And did they cause serious bodily injury? Yes.
Brandon.
It caused respiratory arrest, cardiac arrest, and death, which is serious bodily injury. Defendants are also charged with unlawful administration of drugs. Now, this contains a number of different elements. Requires that you find that the defendant intentionally, for a purpose other than lawful medical treatment, caused physical or mental impairment to Elijah McClain by administering a drug capable of producing the intended
could
harm
be.
without consent. Okay.
Oh, did I
Did
do
the
that,
defendants
or did you do
intentionally
that?
give ketamine?
That was you.
Yes. Did it cause mental impairment and physical impairment to Elijah?
I don't know how I do
Yes.
that.
Was ketamine capable of producing that harm? Yes. So now let's talk about the 2 elements that I skipped over there. Was it for a purpose other than lawful medical, Was it for a purpose other than lawful medical treatment? It was. Lawful medical treatment has to be a bona fide medical purpose. Here, the defendants were not operating under their protocols. There was no indication that Elijah needed ketamine, and you've heard multiple experts say that giving it was for no medical purpose. This was not for a lawful medical treatment. And then finally, to show that it was done without consent, defendants here never did one thing to try to obtain Elijah McClain's consent to any treatment, and no reasonable person would consent to an overdose of a drug that they did not need. Finally, you'll see the defense of special relationship. This requires that three different things be true. That the defendant has to be a duly licensed paramedic acting under the direction of a licensed physician who used reasonable and appropriate physical force to promote the physical, which he reasonably believed would promote the physical or mental health of the patient. And that he reasonably believed that no one competent consent could be consented, and that a reasonable person wishing to safeguard the welfare of the patient would consent. All three of these things have to be true in order for the defendants to invoke this defense. None of them are true. Every single element of this is not disproven beyond a reasonable doubt. First, they were not acting under their protocols, so they were not acting under the direction of a duly licensed physician. Second, they did not use reasonable and appropriate force, and they did not reasonably believe that this would promote the physical or mental health of Elijah McClain. And finally, there was no emergency here, and there was no basis to reasonably believe that anyone would consent to an overdose of a drug they did not need. The defendants have now had a chance to tell their story twice. Once in their police interviews just a few weeks after this happened, and once to all of you just a few days ago. And in all of the things they said, they didn't say one single word that reflected any remorse for what happened to Elijah McClain. Not one. And in all of the things that they said, they didn't take any accountability for any single one of their actions. They didn't admit that there was any single thing that they did wrong on August 24th, 2019. They didn't admit that there was anything that they could have done better. They expressed zero accountability and zero remorse for their reckless and callous decisions, the decisions that killed Elijah McClain, their patient.
All right, folks on the jury, I think we're gonna take our break at this time. Again, you've received the evidence and the instructions and part of a closing argument, but it's not time to start deliberating. Don't form or express any opinions yet. Do no independent research, avoid any press coverage. Let the court know if anybody tries to speak with you about the case. Hopefully we can have you back up here in 15 minutes or so.
I think she did a disservice to her case by going emotional when she clearly has a factual argument that at the very least is compelling. I don't like that. I don't like what she did personally. What's the saying? If you've got the law on your side, fight or use the law. If you've got the facts on your side, pound the law, pound the facts, or if you don't have either, pound the table. She pounded the table, and I don't think she had to.
She didn't need to pound the table at all.
That's why
I'm excited to see. I'm sure she's not going to be doing the rebuttal closing. I'm sure it's going to be the dickhead prosecutor. Sorry, everybody. I know that is not a nice word. But the one that I can't stand, but I love sometimes. And I think I'm probably going to love him in his closing. Maybe. We'll see. I either love him or I hate him. Do you see how packed the courtroom is?
Yeah, they were filing in.
Do you see how it's segregated? Like, this side is all white. This side has...
I didn't notice that until just now.
Like, there are 2 rows of mostly black people, and then the back 3 rows, I can't tell. There's, like, definitely a bald white guy in the back, but But all of these people on the left-hand side are white as can be. I just found that a little odd.
Yeah. I didn't notice that till just now.
Who are they standing up for? Oh, the jury. That's weird, but okay, so look at that. You can tell they're all like in the EMS or police officers or whatever. They all stand up for the jury. Nobody on the state side, because those are, you know, those are like Elijah's friends and family. Right. They don't stand up. Oh, see these three white bald guys in the back? I think those are actually
spillover from the
defendants, but they don't fit behind the defendants.
I think so too.
So I think these first 2 or 3 rows might be full of Elijah's friends and family, and then after that it's empty. The whole entire left side is full.
Which I would expect, right? The paramedics, and they're going to have a lot more support in the court system. I would suspect.
I mean, yeah, and also because this case took so long to come to trial that I don't know. It's sad. It's really just very sad.
This whole thing is sad. Everything about this case is sad. Yeah, Aries, we're still green.
Oh yeah, don't get stabbed, Brandon.
Jurors entry.
Agreed.
Right, our jurors have returned. Please be seated.
Yeah, right.
Court will call up 21 CR 2800 and 21 CR 2806. The parties and counsel are present. Closing argument for the defense.
Good afternoon, members of the jury. Prosecution would have you believe that this is a simple case. Simple, straightforward case. It's not.
I hate when they say this.
It would have you believe that Mr. Cooper and Mr. Cichuniec planned to kill Elijah McClain.
He lost.
There's absolutely no evidence to support that.
This guy's voice bugs me.
This is a very complex,
his tone and mannerism.
complicated case.
It's like so
a number of witnesses, a number of expert witnesses have been called on both sides. There have been differences and disagreements expressed between these experts, and you all, as the jury, are going to have to pick through those. But there are 3 things that the evidence in this case has surely proven. First, that Elijah McClain should still be with us. That his death is and was a tragedy. The second is that in August of 2019, there were a lot of systemic problems with both law enforcement, the practice of medicine, the practice of paramedic medicine that needed to be fixed. Third thing, that things are not always as they appear. This starts with Elijah McClain walking down the street, doing his own thing, maybe waving his arms, maybe listening to his music, listening to his headphones. He's wearing a jacket, he's wearing a ski mask. So what? So what? Maybe he's cold. Like his friend Marty said, he often got cold. Whatever the reason, a second young man calls the police. And the second young man reports that Elijah McClain is acting sketchy. And from that, both the systemic problems start showing themselves, and the fact that things are not always what they appear start showing themselves. Elijah McClain's not doing anything sketchy. He's going to a convenience store to buy some things to drink. And then he's going to walk down the street and go home. Things aren't always as they appear, not as they appear to a 911 caller.
I hate this argument.
Follows her protocol. She asks a set list of questions. She does. When she gets to the end of that, she dispatches police.
Oh no.
To the area of Evergreen and Williams.
Better find that super glue.
Nothing more.
I'm just going to throw it away.
Somebody else looks sketchy. We now have police involved. That's a systemic problem. Police arrive. Elijah McClain is ordered, stop. He doesn't. So what? Does he have to stop? He's not doing anything wrong. He shouldn't have to stop, should he?
I'll allow some leeway for closing argument.
Hey, Scott, what's up, buddy? Welcome.
But when he doesn't stop, and he doesn't do what the police tell him to, he immediately gets put in the category of non-compliant. Non-compliant with police orders. And the whole reason for why he didn't stop is completely lost. That's a problem. And that part of what the police later tell Fire is actually true. Elijah McClain did not comply.
You're not
with
wrong,
the order
Matt.
to stop.
You're not.
wrong.
It's an
Right,
example
mind their
of
own business.
a way
This would have never
overly
happened had that
subjective
person not
term
called.
being used in protocols, in training, that leaves people to guess at what it means. What does it mean to be non-compliant? You saw a video during one of the trainings. Gentleman who busts through a fence while police are trying to take him into custody is non-compliant. Technically, Elijah McClain saying, I'm going home, I'm not doing anything wrong, leave me alone, and continuing to walk on his path,
Hi,
non-compliant.
atheist.
What's up, atheist? How you doing, buddy?
Failure to distinguish in a meaningful way between these two situations, the systemic problem for paramedics. Why do I say that? Well, what does a paramedic do? Was Elijah McClain non-compliant? Yes.
Did you
Was
say hi
he
to Scott?
non-compliant
I did.
enough to
I
check
did.
a box
Okay.
on excited delirium? Who knows?
Hi, Scott.
Who knows? How would you know? The witness called by the prosecution, Dr. Mitchell, talked about some issues of systemic problems in medicine. He talked about the opioid crisis. He talked about fixes for things that were a problem with the system, not keeping track of deaths in custody, and wanting to fix that because there were problems with the way medicine was practiced. And there are ways to fix problems, systemic problems.
Objection to court's prior order to all the systemic stuff.
All right, I think the court's order dealt with things that occurred afterwards, so he's not there yet.
The system can be changed. Paramedic system can be changed. System of medicine can be changed. Regulation, legislation, malpractice cases.
Objection, Your Honor.
I think we need to back off that a little bit, so sustained.
Yeah, buddy. They already did that.
You don't do it by criminalizing the conduct of people.
I'll allow it.
Go ahead and
Do it
back them.
by
Oh, that are-
criminalizing
Well, that's
conduct
cool of the
people
judge.
who are attempting to comply with the protocol. With what are basically their marching orders, the rules that they follow.
This is the defense closing.
You saw the training that was done in this case. Saw, and I'll go back to it later in my closing argument. Emphasis upon excited delirium. The effect that can have on people. It's a major medical issue and people can die from it. That's what paramedics were taught. Not that ketamine is fatal, but that not giving ketamine if somebody had excited delirium was fatal. That's what they were trained. That's what they were taught. That's what their protocols say. 500 milligrams of ketamine is a bad practice. A large dose of ketamine can increase the risk of respiratory depression. That's what they were specifically taught and trained. Not that ketamine is fatal if you give it. Excited delirium is fatal if you don't give it. Speaking of the police, there's another problem.
Yeah, thanks for using your mic, buddy.
Right.
That's at issue here as well. Along with the word
He couldn't remember.
non-compliant, look at some other words. Agitated.
This
No
is
training, there's no definition. When do you become in the category of agitated? Paranoid,
That's funny.
out of control, danger to self and others. Paramedics have much less training
Oh, that's
than doctors have, are required to go in and make a very rapid judgment, to decide these subjective words and decide immediately if they apply. Because excited delirium, as they were taught, is a major medical problem and people die from it. And the whole reason
Yeah, but it's not.
the waiver regarding ketamine
Yeah,
is
it's no longer
undertaken
considered
is
that.
because there had been an uptick in Aurora in 2019.
That's
They were seeing more and more cases. as
Oh, the
Dr. Hill
same time that
testified
they
to
got
yesterday.
the ability to use the
And as it
ketamine,
says,
there
and
was
I'll
an
put it up there in
uptick.
one of their protocols,
when they
we should
started just the
address
culture
aggressively
of chemically restraining
problem of an agitated
people
patient
before they went to jail.
immediately.
It's crazy. They
Weird
both
how
occurred
that
at the
works.
same time.
Shocking.
There is no protocol in effect in August 2019 that tells paramedics, what do you do when police are all over a potential patient? How do you deal with that? See, no training on that.
Good luck
There was
with
no
that.
protocol. There was testimony. There was no protocol.
Oh God. Or talk about a
And
bee.
they must walk a line between lots of different things.
My dog's
Don't make the situation worse. First off, do no harm. You're being told there was just a violent altercation between police and Mr. McClain. From what you can see, it seems to still be going. From what you can see, Mr.
I don't know
McClain
if I
appears
believe
to
that.
still be moving. Police are clearly still giving him commands. Stop. We told you to stop. We repeatedly told you to stop while pushing him on the ground, holding him on the ground, slamming him on the ground. This is what.
Stop
more
squirming
than
as I apply pain.
paramedics see. Even before this starts, they
Yeah,
get a call.
dude.
Medical assist to police department. That's it. They park the engine where? Not anywhere real super close to Elijah McClain,
What does that have to do with
about a
it?
block away.
Oh,
What do they see
oh,
as they
because
walk up? That's very unusual.
their equipment
That was
was
testified to.
like over a
Great
block
deal of
away.
police cars. For a whole block, police cars. So they can't get the engine any closer. They get up to it, and Captain Cichuniec testified to, it's unusual to see that many officers, and that many officers on top of somebody. And that's one of the things that the paramedics are seeing. Mr. Cooper, and Mr. Cichuniec are seeing those things as they walk up. As they walk up, Dan DeJesus. And I implore you, watch those body cams. But when you watch them all. Watch all the way through, including in the hospital, when they're trying desperately to save Mr. McClain's life. These people who supposedly planned to kill him.
Also,
As far as they can tell, from what
Pause.
they hear. from
I
what they
I
see,
want to let this chat know about something. I don't know if y'all have not watched, was it The Expert last night? Yeah, The Expert stream from last night. I know you all were there and you witnessed us having to name the ducklings. Please go and see the shenanigans that they put on last night. I was so upset. So upset.
We had a lot of fun last night on Expert Stream.
There has been a violent altercation.
Oh,
between the
God.
police and Mr. McClain, and it seems like it might still be going. They have to walk a line. Don't make that situation worse. You have a patient that is agitated, that may be creating, in fact, lactic acidosis through struggling, may have already created that situation in himself, and you can't make it worse.
I thought we were going to talk
Also,
about the
we're told,
ducklings.
first priority.
That's what she was talking
Make sure
about.
the safety of yourself and your crew. Can't help somebody else if you are hurt yourself. What does that mean? Got no protocol for accomplishing this. Do you have any questions?
Hi, Farrell. How you doing, babe?
That scene. Prosecution wants to tell you, well, the paramedics should have been in charge of it. Mr. Cooper, apparently, when one officer, I used the word body slam, You decide for yourselves watching that video. I stick by what I described it as. It wasn't repositioning to me. Maybe there was some repositioning incidentally involved. It looked like body slam to me. You decide. You're the jury. You're the finders of fact. What is Mr. Cooper supposed to do at that point? Say, hey, get the heck off of my patient. There's a sergeant standing right there. This officer's superior officer is standing right there. Not only doesn't do anything about it, he doesn't say anything about it, he doesn't stop this officer. He later comes to court and describes that as a repositioning and not a body slam. But a paramedic was supposed to somehow intervene in this. You saw Mr. Cooper testify. You saw the kind of man he is. Mr. Slothauer would ask him something, he'd say, I don't remember, I'm sorry. That is not a confrontational individual. He was supposed to say, get off my patient, get off him. That officer. And instead, he says, not once, twice, we can just leave him there. When he says it, watch the video. Both times, Mr. McClain is in the recovery position. He's not in a prone position. He's trying to say, please just leave him there in the recovery position. I'll wait. You're not going to take him out of handcuffs. I'll wait till I get my tools here. He doesn't have it there. He doesn't have what he's been instructed to get. Even if he never gives ketamine, he needs an ambulance. He needs a stretcher. That's not there. The police are not letting Mr. McClain go to wait for the ambulance. Mr. Cooper comes up and says, do we know if he speaks English? Could he have said,
weird.
Sir, do you speak English? Can I talk to you? Sure. He could have done that. That doesn't make this a crime, like they want you to believe. That doesn't make this reckless. That doesn't make this criminally negligent homicide. It doesn't make it second-degree assault. It doesn't make it any crime. When he asks them, after he asks them, within a few seconds, check me, watch the body-worn camera. I believe it's within a few seconds. Elijah McClain says, I can't fix myself. If you have no context of what's going on, if you haven't seen the Shell video, if you haven't seen body-worn cameras of officers interacting with Mr. McClain previously, if you haven't seen the build-up to all of this,
Hey, Gutters
these two
Pub.
gentlemen have not seen.
Welcome.
That comment doesn't make a lot of sense. I can't fix it. And you could say, should have asked, what do you mean? Things I would suggest in that regard. One is what happens immediately after Mr. McClain says that. Apparently, the officer takes it in his head, he'll fix him. That's when he repositions. The second thing is, remember the video you saw with Sergeant Leonard
No,
trying to speak to Elijah McClain?
he was not.
And he's leaning down. They offered it to say, well, he wasn't scared of him, but he's got a gun and a taser. Yeah, he's not scared of him. But what does he do? He says, sir, we need to know, what did you take? You're not in any trouble, sir. We need to talk to you. We need to find out. You need to try to help him. We've got no answer. No answer. And so the prosecution wants to believe that Mr. Cooper should have gone back and done all this, and that would have borne fruit had he done it. A, the first time he tried talking, even in the area of Mr. McClain, it resulted in Mr. McClain getting slammed to the ground. And B, there's evidence it wouldn't have borne fruit in any event because it didn't earlier. Another person tried that tack and it didn't work.
Okay.
I don't like this guy.
Me either, man.
There's another thing that's not covered in any protocols. How do you estimate somebody's weight?
Project Metal, what's going on, brother? Glad you're here.
Hey.
You have to, they believe, because of what they've been trained, that they see signs or symptoms of excited delirium, and what they have to do is give Mr. McClain ketamine. What they've been trained. And it's dose-based, so they have to come up with a weight. Mr. Cooper said, I tried to compare him to myself. And I tried to take off about 50, 60 pounds. They're trying to make a judgment, not only just trying to estimate somebody's weight without any instruction on how to do it, but somebody on the ground, in the dark, they do have
What's the
laptops,
next
they have the laptop with the light, the shining lights on it. And the body cams have the effect of making this look bright as day, which is not the case. It's relatively dark. They're in a grassy area. Mr. McClain is on the ground, not standing up, which makes it somewhat easier to guess somebody's weight, wearing a jacket with officers on top.
State's closing was a little more emotional based than I think it should have been, but otherwise not really.
Mr. McClain moving and the officers are holding him down. It's movement
Not that I noticed anyway.
going on. And they're trying to estimate a weight. They got training.
Oh, yeah,
We
yeah,
heard
yeah.
about this.
Jury
300,
questions.
400, 500. And we heard,
The
well,
Allen
that's just a
charge.
starting point. Well, that's just a guideline. Well, where's the rest of it? That's the starting point. Where's the rest of the training on how somebody is supposed to gauge another human being's weight? Dr. Hill said, well, under oath on stand, that was a miss. Yeah, that's a huge miss. Because you're asking people to administer a drug without an ability to figure out how much somebody weighs. Could you ask other officers? They're not trying to assess Mr. McClain's weight. You could ask him, again, without a born fruit, he's been asked other questions to no result. What they're told is, you've got to come up with a way to give ketamine or this person could die. Yes, wrong, they're going to charge you with a crime, contributing to someone's death. Things are not always as they appear. It's really from the appearance. It's from the optics that the prosecution asked you to convict Mr. Cooper and Mr. Cichuniec. Because it makes us sick. Watch a video, know how it's going to turn out. The sad, terrible ending to it. We all hindsight at this point. But they didn't. When you watch it and you know that somebody's going to die,
This is true.
it makes you feel like, why don't you do something, anything? Don't just stand there. Causes sadness, and frustration, and anger. And I talked about that in jury selection and told you it would. It does. Dr. Mitchell testifies, this young man needed help and they didn't help him. That's not true first. It's
Yeah,
not part of what
it
these
is.
charges require. Second,
It is true. That is true.
assessment.
They needed
You do an
help,
Assessment without putting your hands on
or he
somebody
needed
else.
help and they didn't give it.
I think that's been proven beyond a reasonable doubt. Again, nobody really differed with that proposition. Italian Chief
No, everybody
Robinette
differed.
assessed Mr. Slotthauer sitting over there. They put on a number of expert witnesses, doctors, including Dr. Buford, who
Did this guy watch the
understands
same
assessed
trial?
Elijah McClain's breathing rate from watching a video that was up there. Didn't have his hands on him. He wasn't kneeling down next to him. Wasn't putting his fingers here like this. And he could tell you not only Elijah McClain was
Yeah,
breathing,
exactly,
but how
Val.
quickly or slowly Elijah McClain was breathing. Obviously, you can do the ABCs through a visual assessment. We saw it. We saw it in action. They assessed Mr. McClain and saw that he was breathing. And he appeared to be breathing too fast. Tachycardia, too fast. One of the signs you're supposed to look for with excited delirium.
They weren't even close enough to see
Paramedics
his
who aren't
breathing.
doctors who don't receive that education or training, put that also in the box with excited delirium thing. Should it go there? Maybe not. Maybe non-compliant never should have gone there either. But it goes there. Tachycardia, diabetic,
exactly.
sweating fast, sweating hard, sweating a lot could be a sign of hyperthermia, that you're too hot. So your body's trying to fix that by causing you to sweat profusely. And so things get put in the box that maybe they don't belong in that box, but it is not correct to say they are not doing an assessment. Mr. Cooper testified. He looked.
The
injury,
difference between the
no,
chats.
no obvious injuries, no blood. Patient's not bleeding. Patient is breathing. Patient has an airway. Patient has circulation going. He keeps moving. Can't move without circulation. Mr. Cooper, after initially trying to talk to Elijah McClain, decides, you can see it. When the officer takes Elijah McClain, I refer to.
Yes,
fine
Scott,
point
this
on
is the
that.
defense.
Cooper's literally taken aback. He backs up a step, and that's when he says for the second time, let's just leave him. You can disagree with his decision to not go up, try to re-engage, but he's done it once. He saw the result. You got to ask yourself, why would you go through that again? The last thing you want is Mr. McClain being in a struggle, being hurt, being slammed to the ground.
I think he's confused too, Scott.
When Mr. Cooper later tries to tell the police, let's take off the cuffs and get him on the gurney, they overrule that. And no, we're going to put him on the gurney first, and then we'll take our handcuffs. Watch the video. Part of what's time spent is them getting a handcuff key and getting him out of their custody, police custody. Because Elijah was breathing the entire time, and you heard the evidence, you heard there's no evidence that he went without breathing for 6 minutes. Numerous witnesses testified he was breathing on the stretcher all the way into the ambulance. He stopped breathing in the ambulance. It was approximately a minute.
Well, this is what Amber thought for sure.
Not 3 minutes, not 4 minutes, not 6 minutes. Approximately a minute. That's not good either. I'm not saying that's good. I'm saying there's no evidence he went 6 minutes without breathing.
I don't know
The
how.
entire time they're interacting, they're watching him. Mr. Cooper is standing at his head, watching him. He is breathing. There did not appear to be a need to get that equipment out of the engine, bring it up here with all the wires on it. Let's hook it all up to him.
Oh, the
You also
verdict
know
came in
that
last night,
delirium can
Scott.
happen to balance. People can bottom out, then all of a sudden they're up again. They don't know if that's going to happen or not. When they're training, he could get agitated again, start flailing around, start biting again. And it's easy to say, well, you should have known better with the benefit of hindsight. If you're that person right there, you've got to decide right away. Tried interacting with him once, got everybody agitated, he got hurt. I don't want to do that.
I don't know who that is.
And I don't know how this person is going to react. If I start trying to hook wires up to him and he starts thrashing around again, what's that going to do? Wrap wires around his neck or somebody else that's trying to restrain him? I don't know how that's going to play out. And there doesn't seem to be a need for it. So they don't do it. The equipment would bring more risk and less calm to the scene.
Thank you, Val.
And so they continue to assess him. And he asked Lieutenant Cichuniec, call for the ambulance.
Thank you.
Ask them for soft restraints and narcs is what he said. And then they discussed ketamine and agree on ketamine. Things aren't always as they appear. Elijah McClain keeps struggling and fighting with police. If you have the benefit of body cam and you get to see where he went from to where he ended up, yeah, you're like, wow, that looks a lot different. Then you come in at 2/3 of it and you go, wow, I've got all these reports, what's been going on, and he seems to still be moving around. Dr. Dragovich used the term, he believed he was crashing, still moving and seemingly breathing. And that's what Cooper sees. That's what Mr. Cooper sees.
No. They're lying,
all of
right?
the things, diaphoretic,
That
breathing
wasn't really
very
his
fast.
email, right?
Does order ketamine.
Not, it was
Then,
Flufferboy
he
2004
told
at
confirmatory
Gmail. Yeah.
information. Always
Yeah.
showed super strength. He did a
He
push-up
was-
with 3 of us on his back. Exactly.
All right, because I hate Binger so much, we're going to take the time to explain this. Binger was the ADA in Kenosha, Wisconsin, who worked under Michael Gravely of the Zachariah Anderson trial.
Oh, I forgot they're the same people.
Oh yeah, Kenosha,
In the
Wisconsin
same
is
county.
dirty. There's no way in hell I would ever drive through Kenosha at this point.
Oh, that's crazy.
Yeah, he an old email popped up they found and it was Flufferboy 2004. He also at one point was living with one of the judges in the county. And there's a bunch of pictures of them on like a boat, you know, all lovey-dovey, shirtless and whatnot.
Okay.
Yeah. Gay.
Wait, so was Binger the dude that was he the prosecutor in Zachariah Anderson or Gravely?
No, Gravely prosecuted that case.
Okay.
And not that I care that he's gay, but you know, gay.
Oh, he really is gay?
Oh, I'm sure. You don't. Yeah, no straight man would have an email fluffer boy. I promise you that.
I mean,
Before he orders up ketamine, no.
Yes,
But
always
it is
shame
true
those
to
two.
back out of a protocol, he gets confirmatory
And Lunchbox,
information.
Binger's
This is
little.
what else he was
Lunchbox.
demonstrating.
I can't remember his real name, but Binger's chubby assistant guy that said, and I quote, "Everyone
You
takes a
repeatedly
beating
stop. You
sometimes."
repeatedly told you to stop. Burns, he keeps struggling
Direct
against
quote.
it. Goes in that box. Mr. Cooper told
Yeah,
me
I'll be
that Elijah McClain appeared to be staring off into space. He thought he might be hallucinating. That's one of the things on
For the feet.
hallucinating. How do you document that? It's one of the things you look for with excited delirium. And it's again, one of those subjective things that you're not given any explanation or training on how do you determine it. Things are not always what they appear. That Elijah McClain had excited
Yes,
delirium.
yes. Here on
You watch
Valhalla
from
awaits,
start
we
to
will
finish.
always take
They
time
have
to
been
shame
able to watch
Binger
from
and
start to
Gravely.
finish. Would
Always.
they have still concluded that? Maybe not. Maybe not, but they did not have the benefit of doing it. And the question is, was it reasonable, given the things they saw and were told, for them to believe that's the protocol they were under? They weren't told that he said things almost immediately to police, like, I'm an introvert. Why are you grabbing me? My name is Elijah McClain. Maybe most importantly, I can't breathe. He didn't get told that he had said that. Sergeant Leonard testified he wasn't even told that he said that by his own officers. So Sergeant Leonard was deprived of information as well. And what did he testify to? He thought Elijah McClain had excited delirium.
Good.
And he's been trained on it. He got imperfect information too. And they've had it drilled into them. If it's excited delirium, you got to move quickly.
Yeah, she wasn't great.
So with inaccurate, incomplete information, with a sense of danger that maybe wasn't warranted, in an unlit grassy area, they're called upon to decide. Not after watching body-worn cameras for 50 hours, not after going back and forth and slowing down and listening to audio, not after consulting a pulmonologist or a pathologist. They've got to make the decision right there and then. Prosecution has not proven a number of critical things beyond a reasonable doubt. Well, put that up there, first one. Using this for demonstrative purposes, Your Honor.
If it hasn't been admitted, we can't display it at this time.
In his initial
You should know that.
autopsy report, Dr. Cena refers to violence of duel and a narrowed left descending artery. An LAD, left anterior descending coronary artery. That's what Dr. Cena refers to. Who else refers to that? Dr. Sundaram refers to that. Dr. Sundaram says there was a violent struggle. I believe Mr. McClain had a cardiac spasm as a result of that struggle. And because of his narrow left anterior descending coronary artery, that caused him to go into ventricular tachycardia, ventricular fibrillation, and asystole, which is your heart stop. And those are the things that Dr. Cena was concerned with. Before Dr. Cena issued his first autopsy report, as he testified, he got threats after doing that.
Did he say Cena?
His name is John Cena. His opinion.
Sorry.
And mysteriously, it was a lot
Couldn't
more
help
like
it.
Dr. Mitchell's. Although there's still a huge difference. Dr. Cena testified that this is in therapeutic.
I mean, he's
range.
so
The amount of
happy.
ketamine actually Elijah McClain systems in the therapeutic range. He said, gestured at the jury box, it wouldn't have killed any of you. As it was an idiosyncratic reaction to the drug, which by definition cannot be predicted. Dr. Mitchell testified that
Go show
Elijah
her some
McClain
love,
had
y'all.
aspiration, acidosis, hypoxia. He doesn't know if he would have survived the struggle with police. Like Dr. Sundaram, Dr. Mitchell opines that Elijah McClain was basically passing away.
Spread the
before
love like
he ever
Binger.
got ketamine.
My daughter always does
It
this.
was directly to the cause of death, which they
And
must
goes, but
prove.
mommy, it's my cute face.
These medics caused Mr. McClain's death. Dr. Moss said it was a stunned myocardium. Dr. Dragovich said he thought it was aspiration. He couldn't comment on the heart because he hadn't seen the echocardiogram or electrocardiogram
guy.
done on Mr. McClain. But he said it was not ketamine because of Mr. McClain's lungs and because that the blood concentration was in the therapeutic range. Dr. Robinson says this was aspiration exacerbated by ketamine. But it's not an idiosyncratic reaction, so he disagrees with Dr. Sina. And he is the only doctor who says that this blood concentration was not in the therapeutic range. Dr. Hurd testified and said, this amount is in the therapeutic range and it would not be expected to cause anybody's death. He was the only medical toxicologist who testified and the only toxicologist who ventured an opinion on that specific thing, including the state's own witness, Mr. Lamb. Nobody testified. There was no evidence that anybody has ever died from a single dose of 500 milligrams of ketamine or from a concentration in your blood of 1.4 milligrams per liter of blood. Now, these experts are all well educated, smart, talented, well compensated, some more than others. And they are all professionals, every one of them, and they are all over the place on cause of death. That is the definition of a reasonable doubt.
I'm pretty sure he is a bottom.
Based on that, how do you know? You don't know that ketamine caused Elijah McClain's death because they have not proven that beyond a reasonable doubt. What I just
Oh, we're
talked
watching
about,
the closing,
Dr. Hill says
atheist.
A large dose is not
We're watching it
500
all.
milligrams of ketamine. It's 10 to 100 times.
Yes, that is weird. Scott, I agree.
They have not proven beyond a reasonable doubt that
100%.
either paramedic engaged in conduct that was reckless, that was criminally negligent homicide. 9 paramedics or former paramedics testified in this trial. Nobody said that deciding this was decided delirium, decision to give ketamine, amount of ketamine given was outside the standard of care. Nobody. Dr. Eric Hill, Robin McKinley, Pete Cichuniec, Daniel DeJesus, Alicia Gonzalez, Jeremy Cooper, Ryan Watt, Gary Ludwig, Travis Chambers, all testified. No evidence. It was outside the standard of care. Look again at the protocols. Look at the boxes. And what do they require? Patient is agitated and a danger to self and others. As I said, how do you determine that? And that's your starting point. Assume the patient has a medical cause of agitation and treat reversible causes. They did. Excited delirium is a medical cause of agitation, and they tried to treat that as they've been instructed to, which is give ketamine and transport as fast as you can to the hospital. Once you give ketamine, you must complete the restraint protocol first, then reassess the ABCs post-sedation and move on to your other things you need to do, including hook up the equipment as the protocol was admitted as People Exhibit 225. Excited, once sedated, patient must be placed on cardiac monitor, capnography, and pulse oximetry during transport, which is transport in the hospital, in the ambulance to the hospital. They were following their protocols. Regarding the
That's disingenuous too.
defense,
That makes it sound like he wasn't in transport from the time they put him on the gurney to the ambulance, but he absolutely was.
what the protocols say there. He testified if somebody has excited delirium, they are presumed to not have decision-making capacity. And from what the medics saw in the interactions, Mr. McClain wasn't saying things to people, and did not appear to have decision-making capacity. We teach them, said Dr. Hill, the medical director, to treat someone with excited delirium under medical implied consent, which is a medical term meaning if this person was rational, they would want to be treated. Under the defense, instruction number 12 and instruction number 26, Mr. Cooper was a duly licensed paramedic. He was under the direction of Dr. Hill, a duly licensed physician.
5 minutes.
He used a reasonable and appropriate physical force, giving a shot of ketamine for a recognized form of treatment, ketamine is, that he reasonably
I love
believed
y'all.
to be adapted to promoting the physical or mental health of the patient, which he had been taught, or excited delirium. And it was administered when the duly licensed paramedic was acting under the direction of a duly licensed physician who testified on the stand. That's what he taught his paramedics. That you can proceed under the medical idea of implied consent. And that's what they did. Doing that means they were not, by definition, reckless or criminally negligent, as instruction number 12 tells you. And doing that under instruction number 26 means they are not guilty of second-degree assault, as the instruction also tells you. The protocol does not indicate a preference for the engine equipment or the ambulance's equipment. It doesn't tell them what specifically to bring to any scene. Protocols are so vague, yet they're having to make the call. There is no evidence that either one of these defendants, either Mr. Cooper or Mr. Cichuniec, intended to hurt Elijah McClain. And that's what's required for second-degree assault. Intended to hurt, intended to do it for a non-medical purpose. They were following their training. They were following their protocols. They were instructed about the wide margin of safety. Ketamine is safe, except delirium is dangerous.
That's
what
actually
it comes
not
down to,
needed for second
that they
degree
were
assault.
trained on.
No.
This case relies on
The stupor one, all you had to
anger,
do was
to
intend to.
sadness,
Yeah.
watching that video over and over.
Putting them in a
I
comatose
have seen
state or
problems with
stupor
jury selection.
is
Yeah.
a
Keep an
acceptable
open mind to
outcome.
consider all of the evidence in the case, to consider the subtle and the nuanced topics, and not just blatant and obvious things. To weigh the evidence in the light of the legal instructions Judge Warner has given, particularly in light of the presumption of innocence and the burden of proof. And to fairly analyze in your own mind, after discussing this with your fellow jurors, whether you have any reasonable doubts about the guilt of Mr. Cooper. These charges have not been proven beyond a reason. Time draws near for you to weigh in on them. Jeremy Cooper is not guilty. We implore you, do not make this tragedy worse by wrongly convicting. We implore you to find him.
Hi, Lynn. Lynn Dalton.
Hi, Lynn.
Thank you. Do the UTB things. Go
On
to my
behalf of
stream
Mr.
too,
Cichuniec.
please.
How you doing, doll? Glad to see you. Merry Christmas. You're off all the way until the 2nd? Goodness.
That's a long time, right?
Hell yeah. Good for you, Dork.
Oh God, now we have another defense attorney. What? They should have let the lady do the closing. She was good.
As a matter of fact, I would agree, John H. I agree completely. I think that the two defense attorneys that have done closing were the absolute worst two.
The worst.
out of
The
the
two
group.
worst. They were the two worst.
Are you
And notice they
speaking?
both- Yeah, but he's not using the mic.
Oh, Judge, please say something to him.
He's not. They never do. What an idiot. Like, if the jury can't hear you, if you sound weak like that, you are going to lose.
A lot of testimony.
Oh, there he
a lot of
goes.
evidence. And now you've just today been instructed on the
They
law.
might not have turned the mic on for him.
And I'm going to walk through some of
They
the
didn't wanna
evidence
hear
and
from him
highlight some
either.
of that for your consideration. You deliberate on these
That
very
makes
important
sense.
questions. And I say very important questions because they are very important. And those verdict forms that the judge read to you are essentially questions to you. But those aren't the only questions that have been posed in this case. And I would submit to you that the prosecution, for the vast majority of this case, through the vast majority of the evidence that they've provided you, have attempted to answer the wrong question and have answered the right questions wrong. The relevant question here is not whether Elijah McClain was suffering from excited delirium. Rather, the relevant question is whether it was reasonable for these two gentlemen believe that he was suffering from excited delirium, that he was acting consistent with what their training and their protocol told them was excited delirium.
He's right about that.
As you heard from Dr. Gill, they're not doctors. They don't diagnose. They assess. They assess, stabilize, they transport. And they do that in compliance with their protocols. And that is exactly what we did. So let's look to see what they knew. Because ultimately, in order to make the decision about whether or not their judgment was reasonable, about whether or not Mr. McClain could have been suffering from the symptoms of excited delirium, is we have to evaluate what they know. Not by the whole body of evidence that we all know. Not with the benefit of hindsight. But what do they know in that instance? That instant when they were making those critical decisions for their patient.
Nice.
Try and treat him to save his life.
I'm so happy y'all got some time off. That's good.
Got 3 remotes up here, so I got to figure out which one works. Down. First of all, what do they know? They knew from the police that the police were struggling with Mr. McClain. And they knew from the CAD notes and when they got on scene that it was a prolonged struggle. It wasn't a short struggle. They knew that the police believed Mr. McClain to be on something, as they were told that when they arrived on scene. They also knew that Mr. McClain was not answering questions by the police, as that information was provided while they were on scene. They could observe that Mr. McClain was breathing fast, that he was sweating profusely. And they were told during the call, once they had, based upon that initial information, made the assessment, this sounds like this could be excited delirium. It's meeting our protocol. It's meeting the signs and symptoms that we've been trained to look for. Then they're told by police that Mr. McClain is demonstrating incredible strength, crazy strength. He almost did a push-up with 3 of us on him. That's what they know. And you've seen the protocol, and you've heard the testimony about the protocol.
Yes.
That information.
Do you ever see on your YouTube analytics that you lose subscribers?
Yeah.
What?
It just
That's
happens.
terrible news.
People unsubscribe. Sometimes YouTube does weird things where they'll unsubscribe accounts thinking that they don't
I don't think
want
I've
to be
ever
subscribed.
unsubscribed to somebody.
I've been unsubscribed a couple times.
Yeah.
Yeah, it happens to me rarely, but a couple times. Don't worry about it. You'll get them back.
Seen that.
You'll get them back.
Within the signs and symptoms of excited delirium. But they're not the only ones. Think about the other evidence you have. The testimony from Dale Leonard, who is also a witness in this case and very similarly situated to Mr. Cooper and Mr. Cichuniec. Because Dale Leonard arrived on scene after the initial incident, after the initial struggle with Mr. McClain by the police. And he too is briefed by his officers about what occurred. He too has the opportunity to observe Mr. McClain breathing heavily, sweating profusely, grunting. Hearing the officers say repeatedly, "Stop resisting, stop fighting us." He even takes it upon himself at one point to assist in restraining Mr. McClain by stepping and placing his foot with pressure on it on Mr. McClain's ankles. Now, he's trained in the police department to recognize the signs and symptoms of excited delirium, and he sat on that stand and he told you that he believed and was convinced, based on what he was told and what he was seeing, that Elijah McClain had excited. That is why he was so concerned. Once the ambulance finally got there, you hear him say, "What's taking so long? What's taking so long to get?"
Farrell's unsubbed me like 6 times now.
Nuh-uh.
Oh yeah. Oh yeah.
What? Why?
I don't know if
What'd you
that's
do?
true. I'm making that up.
I submit to you.
I submit to you that you should stay by the mic
Based on
and
the
stop talking.
information that these gentlemen had in the short amount of time that they had to process it, that it was entirely reasonable for them to believe that Mr. McClain was suffering from
Whoa.
excited delirium. And so they chose that protocol and they went down that protocol. And you have that protocol in evidence. And you can read for yourself. The protocol says give tether. Then you wait for it to take effect. Then you complete the restraint protocol, which is moving the patient to a gurney, applying soft restraints. You reassess the ABCs. You put them in the ambulance and you connect them, the monitoring, the heart monitor, the monitoring equipment, and you get that person to the hospital. Because the protocol tells you that rapid sedation, the protocol uses the word tranquilization, but rapid sedation is required to treat that condition. I want you to consider the timeline of events here. And a timeline is very important. Because unlike what the prosecution wants to suggest, the ability of Mr. Cooper and Mr. Cichuniec to fully take control of Mr. McClain and undergo his treatment for suspected excited delirium is frustrated by a number of things that are out of their control. So at 10:32 p.m., you have the 911 call that is placed by Mr. Vega to police dispatch.
Mr. Vega?
At 10:43 p.m., Officers Woodard, Rosenblatt, and Lima confront, stop, and detain through physical means Mr. McClain. And the struggle ensues. At 10:46, after 2 carotid holds have been attempted, 1 apparently successfully, the police ask for fire to be started, and fire is dispatched. About a minute later, the ambulance is dispatched. And you heard testimony that in Aurora, you have the Aurora Fire Rescue, the fire department, and then they have a separate organization that they contract with, Falk Rocky Mountain, who provides ambulance services and transport. And they have their own dispatch, and they're dispatched separately. But they're dispatched within a minute of each other. Unfortunately, AFR arrives first without the ambulance, out of no control of their own. And they arrive at 10:50. And they come up on scene, and as you heard and you know the evidence, because of the heavy police activity, they aren't able to march as close as they normally would, or what they would like to. So they walk it in. About a block and a half was the estimate. And they come to this scene. And what they see is Mr. McClain on the ground being held down by not 1, and not 2, but 3 officers. And they repeatedly hear commands being given by those officers. Stop fighting. Stop resisting us.
Hey,
You've been told multiple times.
I'm behind a little.
At that point in time, they don't have access to their patients. It appears to them, reasonably, that the Aurora Police Department is still actively struggling with their patient. And then they wait. They make that assessment based upon the information they need. That reasonable assessment that this looks like excited.
No.
They're powerless to do anything.
I know the outcome of the case for sure, and I think Val has an idea.
They don't have the drug that their protocol calls for to treat that.
Oh,
They
I
don't
forgot.
have it. It's not there yet. And even if they did have it, they don't have a gurney or the soft restraints or the ambulance to transport it. So they're left with several bad options. And what they do is what they're trained to do. They visually assess the patient. And you watch those cameras. Once AFR is on scene, there is always someone, 2 someones, 3 someones, and oftentimes 4 someones watching and observing Mr. Muhammad. Make sure that he's still breathing, which he was the entire time. That his airway is not obstructed, which it wasn't the entire time. And that he is demonstrating that he is consistent with having circulation. He's moving. He's he's not talking or making sense, but he's grunting, he's making sounds. They're constantly assessing and checking those ABCs. Until 10:56, 6 excruciating minutes. Six anxious minutes.
Y'all, somebody just walked in my house. I was like, who the F is this? It was Mrs. Valhalla. She forgot to tell me she got off work early. It's like, what the hell is happening?
Your mic is different again, I think.
3 officers.
Is it?
Nope.
Oh, okay.
The ketamine arrives, the ambulance arrives.
Talk about
Lieutenant
getting
Cichuniec
the
goes
heart
to
rate
get the
going
gurney.
though. Jesus.
Prepares the gurney, brings it to the patient's side.
I got excited, y'all.
Tells paramedic Walker, based upon his
I'm
conversation.
glad you didn't
calling
hurt
them.
anybody.
So paramedic Walker can draw that up. And he brings it to paramedic Cooper about 3.5 minutes after the ambulance. They finally have the drug that their protocol tells them they need to administer to their patient.
Hey, Aaron Hack, how are you?
And paramedic Cooper administers that drug pursuant to his protocol.
Welcome.
So that he can hopefully end this struggle that is going on. Get the police off of his patient, get his patient onto the gurney, restrained for his safety and theirs, in the back of the ambulance, to the hospital.
You know.
So they wait a short period of time for the ketamine to take effect, but he's still handcuffed. He's still not completely theirs.
One of my
Cuffs come off.
not one of all of my friends. Y'all, all of my friends know not to just come in the house, right? Obviously, and they all know not to show up unannounced. Like, don't even knock on my door without me knowing you're here, because it, you know, that's just who I am. She walked in. I was
Yeah, she could have been unalived.
The cuffs come off at 11:02, and finally,
got to get that heart rate down a little bit.
when you watch those videos, you watch what they do as soon as they do. They're up. Cooper's calling.
Yeah, the goats are not good guard dogs.
For CO2, monitoring,
No.
idle, and they're
My
off
dogs,
to the ambulance.
however, are good guard dogs.
They're not stroking.
Oh, you have dogs too? Oh yeah, duh. I've heard your dogs before, I think.
I've got 2 pit bulls.
They're moving
Oh,
as efficiently and as quickly as they can to get the patient into the bus and to the hospital. They are in the ambulance 20 seconds after the handcuffs come off. Kind of on the video. Handcuffs are off, he's in the restraints, they sit him up, and they're off. And they're at the back of that ambulance 20 seconds later. But all that time, between 10,
Indeed.
43,
Get the
and 11:02,
woos.
Mr. McClain is in the custody and control of law enforcement.
What's up,
Not
Matt
Farrell.
Turner?
oh, is this a different person?
Now-
No, this is Farrell, right?
I'm not sure.
You've heard lots of testimony arguing today about assessments. And the prosecution has been incredibly critical of the assessment that was performed by AFR. Not only the assessment of paramedic Cooper and paramedic Cichuniec,
Might have been there for a
but
minute.
also that of DeJesus and Brad. They seem to not want to acknowledge, despite all the testimony from the witness stand, Robin McKinley, Gary Ludwig, Dr. Gill,
Oh, they just said my name.
DeJesus,
Say my
Brad,
name, say my
the
name.
Say my
visual
name.
assessment by paramedics,
The one
visually
is
assessing
a-
ABCs is appropriate. It's within the standard of care. But don't take their word for it. Take your own praise. Believe your own eyes what you saw. Battalion Chief Robinette from the stand, assessing Mr. Slaughauer, his ABCs. He wasn't standing, he was just sitting there. And see, he's breathing, his airway's clear. Here's the half circulation.
Oh, that's funny.
You saw Dr. Buther do the same thing from that witness stand. Even more amazingly, He's watching a video through plexiglass. And he manages to calculate the heart rate, the breathing rate, the respiratory rate of Elijah McClain from
No,
a
he
grainy
doesn't.
body-worn camera at various angles. From the stand, using body-worn camera, he's able to assess and render an opinion about Mr. McClain's aspiration and when he's aspirating. He's able to view the shell video and render an opinion that Mr. McClain, who is wearing a mask at the time, is breathing normally. Never speaks to Elijah McClain, never asks his name, never puts his hand on him.
Also, lawn and
Makes
Crim.
medical diagnosis. But they want
Zach
you to believe that that
and
somehow
Fear
deviates from the
the-
standard of care.
Feral Flower Housewives.
We're not done. How about Dr. Robinson? Dr. Robinson from that stand, he opined at various times in the video that Mr. McClain was suffering from hypoxia and that hypoxia moved to lactic acidosis. All from a visual assessment of a body-worn camera video. Now, they also had the benefit of 20/20 hindsight.
And
They had
also
the
just not
benefit
being dickheads.
of what a horrific and tragic outcome this was for Mr. McClain. Information these gentlemen have, information they desperately wish they.
Dude, you are so boring.
We're still not done with visual assessments offered by the prosecution's experts. Dr. Mitchell. Dr. Mitchell sat on that stand, and from watching the body-worn camera,
Yeah,
he
Mac.
testified and diagnosed not once,
Mac Turner.
not one, but two aspiration episodes that Mr. McClain suffered. He diagnosed at that point in time, of course, with the benefit of hindsight, that Mr. McClain was going through a slow decline, that he was likely suffering from metabolic acidosis, that he had hypoxia. 5 medical diagnoses from Dr. Mitchell from a visual assessment of a body-worn camera. They want you to believe that deviates from the standard of care. That somehow was lazy work by paramedics Cooper and Cichuniec. Ladies and gentlemen, these two gentlemen didn't have access to body-worn. They certainly didn't have 50 hours.
That is the tough part,
Fast
Scott.
forward, pop, slow it down, rewind, zoom it in. They made their decision in real time based upon what they could see and what information they had. There's a couple of, well, I want to address kind of the 6-minute
I'm glad you got that fixed.
Oh, Farrell.
Oh, Feral.
and contradict that. So another timeline for you for your consideration.
Did I do that or did you do that?
Ketamine is
You did.
administered at
I always
10:59:22, based upon the body-worn camera footage. Okay. At 11:01:03, paramedic Cooper says, "Let's get him on his side. Let's take the handcuffs off and let's get him on his gurney." He, of course, is overruled by Officer Rodimo, of the Aurora Police. Says, "No, let's get him to the gurney first, then we'll take our handcuffs off." At 11:01:13, Mr. McClain is on the gurney. At 11:01:40, the handcuffs are removed. And at 11:02:16, they're off to the ambulance. At 11:02:32, they're at the ambulance. And at 11:04:35, Lieutenant Cichuniec advises over the radio that Mr. McClain has court. That is approximately 5 minutes from administration of ketamine to announcing the core. The core gets announced, you've heard the testimony, after Mr. McClain has stopped breathing, after they've intubated him, and after they've applied oxygen with the bag valve mask, the BVM. This notion that he went 6 minutes, was neglected for 6 minutes, or went without oxygen
Yeah, I
for
don't think
6
that's
minutes,
true.
you know is not true.
Yeah, it's not true.
Paramedic Walker told you he's breathing all the way to the ambulance. EMT Gonzalez told you he's breathing in the ambulance. It's not until about a minute after he's in the ambulance that he stops breathing. And then the CPR protocol and the life-saving measures are instituted and initiated. Measures that Dr. Buther, the state's expert, tells you were remarkable. The life-saving efforts were remarkable. The placement of the intubation tube was impressive. Does that sound like paramedics who didn't care, who were callous, who were inconvenienced? This is the video at the hospital
Dude,
of
no.
those same paramedics and
The
EMTs
inconvenienced
trying to
argument was
save Mr.
bad on
McClain's
the
life,
state's part.
trying to get his pulse back, his breathing back, his heart rate back, all the way from the ambulance into the hospital, into the trauma room to complete their 2-minute cycle. To characterize these individuals as callous, not caring, as wanting to administer ketamine so they can just get rid of Mr. McClain so he's not their problem anymore, is not only wrong, it's disingenuous. Now, of course, we have Dr. Buther, who testified. This is National Jewish. This is where Dr. Buther works. And he testified about ketamine and his experience with ketamine, all in a hospital setting, not in a pre-hospital field setting. This is Dr. Mitchell's office, where he spent those 50 hours meticulously poring over body-worn camera to come up with his conclusions with the benefit of 20/20 hindsight. Here's Dr. Robinson's office, his pain clinic, where he did the same thing, poring over body-worn camera footage, second-guessing every move. And this is Aurora Fire Station 2. This is where Jeremy Cooper and Pete Cichuniec work. This is the back of an ambulance. This is their office, where they don't have the benefit of body-worn camera video and the benefit of 20/20 hindsight. This is where they work. Dark, uncontrolled scenes where safety is a priority and life and death decisions are made in split seconds. So what did they know? Well, they knew those things we were talking about. And they knew what was taught to them in paramedic school. As you heard Dr. Hill testify, the 1,600 or 1,700 hours in paramedic school. What didn't they know?
That's funny.
Well, they didn't know the tragic outcome here. They didn't know what was on the shell video. They didn't know the information and the circumstances of the initial contact by law enforcement in this case. They didn't know about the statements made by Elijah McClain that he was just going home, that he's an introvert, that he's just different. They didn't know that he claimed not to be able to breathe not once, but 7 times before their arrival. They didn't know that Mr. McClain had vomited while wearing his mask, leading to increased concerns for aspiration. They didn't know that a carotid hold, beautiful typo in it, was applied twice. They didn't know that he was believed to have lost consciousness. And they didn't know
They were told
what all
that.
the people's experts knew from that
Yeah, they were.
17,000 to 18,000 hours of medical school and residency to evaluate that scene. And you heard Dr. Hill talk about the standards of care that paramedics have, that's applied to paramedics. It comes from the protocols. And the standard of care is different
What's up,
in a
Alex?
hospital setting
How you
where
doing,
the people's
bud?
experts work and a field setting.
Is that
pre-hospital
Alex or
where Mr.
Axel?
Mr.
We call we
The standard of
Alex.
care
It's
is
Alex.
Doctors
Alex?
have all this training and education
It's Alex.
and experience will apparently be able to visually assess and diagnose from a witness stand looking at body-worn camera footage compared to the 1,600 or 1,700 hours that a paramedic has. That the standard of care is different for a doctor than it is a paramedic. Yet the prosecution brings you not paramedics to evaluate paramedics. They bring you doctors to evaluate paramedics. You should take that into consideration as you deliberate in this case.
-1. What do you mean?
I want
I've
to
been
talk a little
drinking.
bit about the charges in this
She
case.
has actually. So we're at least at 0. You've had
Man,
3?
The elements are that the
Damn,
defendant
girl.
in the state of
This
Colorado
has been a slow
recklessly caused
closing.
the death of Elijah McClain. And in your instructions is the definition of reckless or recklessly. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk that a result will occur or that a circumstance
there.
exists.
We'll get there.
Well, what is the substantial risk or result in this case? It's death. So in order to be guilty, they must know of the risk and they must disregard that risk. And that risk must be an unjustified one. Well, what does the evidence tell you? Well, first of all, knowledge of the risk. What is the evidence of their training? Their training is that ketamine is safe. They were never trained that ketamine could be lethal or kill. That there's a broad safety profile, even in dosing. That you can make mistakes in dosing and it's still safe. That the side effects are rare. And that they increase with large doses, but you heard large doses are 10 to 50 times the dose.
Is he
I
sped
hear.
up?
But even in large
Yeah.
doses, they
He
increase, but they're
doesn't sound
still
like it.
rare.
He must talk
Repeated
so slow.
testimony about how
Right.
safe ketamine is in a pre-hospital setting,
Yeah, he sped up.
safe at those levels. You heard evidence that the actual blood concentration levels in Mr. McClain's blood were therapeutic. Not only were they therapeutic, they were at the low end of the therapeutic level, nowhere near the toxic levels where you see in the literature fatalities.
Do a poll. See who wants to speed it up.
How could they knowingly disregard an unjustifiable risk if they were never trained the risk was there?
I don't think he's got that much longer.
How do we do a
Negligent homicide.
poll?
You also have that element in your
Yeah,
instructions.
we're almost there.
That the defendant in the state of Colorado caused
You
the
do
death
it
of
in
Elijah
YouTube.
McClain by conduct amounting to criminal negligence. What does that mean? A person acts with criminal negligence when through a gross deviation of the standard of care
No.
that a reasonable person, or in this case a paramedic, would exercise. That he fails to perceive a substantial and unjustifiable risk that a result will occur or that a circumstance exists. So let's talk about gross deviation from standard of care and the standard of care. Well, you know, the evidence tells you the standard of care is developed
Damn,
through
dude.
protocols.
He must talk so
You have the
slow.
protocols and evidence. 0030 protocol, the general guidelines tells you that the protocols define the standard of care for medical professionals in Aurora, Colorado. Okay? In order to prove a gross deviation, or in order to prove this charge, criminally negligent homicide, they have to do more than just prove a deviation from the protocol. They have to prove a gross deviation. It's not a checklist. You did this, and you didn't do this, so therefore it's a gross deviation. No. It's a gross deviation, a blatant or a flagrant deviation. They have to do more than just nitpick at the care provided here and simply put up and assert, well, they could have done better. They could have asked his name. They could have done this. They could have done that. That is not evidence of a gross deviation from the standard of care. I submit to you, they haven't even proven to you what the standard of care is. The defense brought you two standard of care witnesses. Robin McKinley, who is a lieutenant firefighter paramedic from the Memphis Fire Department with over 22 years experience and over 39,000 calls for service. And she told you and explained to you that she reviewed the AFR protocols. And she testified to you that not a single thing they did on that call deviated from the standard of care established in the protocols. Not a single thing. Dr. Hill, who wrote the protocols, explained and went through those protocols about what the intent was of the protocols, what the protocols require, what the standard is, so that you could apply that standard to the conduct and the evidence you have in this case. Prosecution, they didn't bring the standard of care witness or expert. The applicable protocols for the standard of care here are the agitated
He's the least
medication
interesting to
protocol and
look
the
at.
Ketamine medication protocol. Look at those protocols. Look at what these two gentlemen did, and you will see
He shapes them.
that they acted in
Tianina knows.
compliance and in furtherance of the standard of care in this case. We're not done with criminal negligence, because once we address the standard of care, and I submit to you, if you find that there was not a gross deviation
She
of the standard
doesn't
of
have
care,
the sound
then these
on.
gentlemen are not guilty of criminal negligent homicide. But there's a second part of it, that the individual fails to perceive a substantial and unjustifiable risk. But we just talked about that on the reckless manslaughter charge. Think of their training, harken back to their training and what they were told about ketamine, and whether or not they knew it was an unjustifiable risk to give ketamine, even to make a mistake in the dosage and give ketamine.
What's that noise, Val?
Want to talk about cause of death?
Valkyrie's digging around in the closet on the other side of that wall.
Nice.
Not sure why. Don't know what the hell she's going after.
Prosecution also has to prove that ketamine caused the death in this case. And I submit to you that they have not been able to do that. Dr. Sina, the forensic pathologist who conducted the autopsy in this case, in his first opinion that was issued in November of 2019, he documented a left arterial descending artery, that LAD that you heard testimony about, the defect in Mr. McClain's heart, and he listed that as a contributing factor to his death. And intense physical exertion, also as a contributing factor. And the intense physical exertion that he's referring to is that struggle with police, that prolonged struggle and pressure and exhaustive struggle with not one, not two, but 3 officers, that contributed to his death. But he couldn't determine what the actual cause was. So he labeled it undetermined, and he labeled the manner undetermined. And that opinion stood for 18 months. In June 2020, the Attorney General's office reopens the investigation into Mr. McClain.
Oh my God, we don't need a history, dude.
In March 27th, 2021, Dr. Sina flies to Colorado, requests a face-to-face meeting.
Did he just pull his
Dr.
pants
Sina?
up?
Maybe.
Rewind.
Goes to his
Can
office
you
and talks
rewind?
to him about Sina flies to
Oh,
Colorado.
yeah, he did.
Requests a face-to-face meeting with Dr. Sina. And
Dr.
goes
Sina?
to his office and talks to him.
His name is
about-
John Cena.
Dr. Mitchell issues a competing report
Oh, you
on
should
June
have just kept
21st,
that up.
2021. Dr. Sina, less than 2 weeks later, issues an amended autopsy report. Now, bear in mind, there is no new medical evidence or information that has come to light in those 18 months. No new toxicology reports have come back. Hey, we messed up the first tox screen. The ketamine levels are actually much higher.
Sorry, Eris.
No new medical evidence. Instead, Dr. Sina claims to have reviewed some additional body-worn camera footage. Now, we know some additional because we know when he issued his first report, he had body-worn camera footage.
Best
Judy,
And
you're
in
audio
so
fact,
clip
boring.
two witnesses
ever.
that nothing
No,
was
it's
withheld
so
from Dr.
great.
Sina. Detective Inqui, Chief
And
District
I have
Attorney Patrick
control. I
Costigan.
could just play it all the time.
No request from Dr. Sina for additional body-worn camera
KLI.
What's up,
footage.
KLI?
Provided it.
KLI.
Neither of them are aware of any information being withheld from Dr. Sina. So what changed? What changed? You heard him testify about the pressure he received, the criticism he received, death threats he received, the personal visit he received from Dr. Mitchell. Dr. Mitchell issues his cause of death in his report as complications following acute ketamine administration during violent subdual and restraint by law enforcement and emergency response personnel.
5 minutes.
Dr. Sina's new opinion says complications of ketamine administration following forcible restraint. Sound familiar? Almost identical. No new medical evidence. Dr. Sina says, I was able to watch.
Bye, Scott.
Merry Christmas, Scott. Merry Christmas. KLI, that's horrible.
And then Dr. Sina,
YouTube is asshole.
he doesn't look very good there. I think those are at his best. Happened after the ketamine was administered, so.
No, Darth, this guy didn't have any he didn't have anything in his toxicology. A little bit of THC and the ketamine that they injected him with.
Correlation is not causation. Sequence, because it happened in that sequence.
Who did you say that
You
to?
all know. You all know.
Darth.
Your common sense, that's a basic
Oh.
fallacy. Well, this happened after this, so this must have caused it. That's all they got. That's all they have. Cause of death.
Who divorced you? Not me.
Where's the evidence?
I'm your sister.
Where is the evidence that this safe drug, given in a therapeutic dose, that no one can ever document has been fatal at those
Yeah.
levels?
1000%
Where
yes.
is the evidence that that killed Mr. McClain? There's plenty of evidence that metabolic acidosis, that aspiration, that the narrowed lag are all potential causes of death. Now, you heard Dr. Sundram, and you'll have to judge for yourself. But the narrowed lag and his testimony about watching Mr. McClain go from ambulatory to speaking to making sense.
Like they didn't need this
struggling,
long, man.
to decompensating,
Oh,
to
okay.
not making sense.
Sorry,
is all
KLI.
consistent with ventricular fibrillation, leading to a lethal arrhythmia. A possibility ignored by Dr. Sina and Dr. Mitchell because they heard that Mr. McClain was a runner. There's no evidence that Mr. McClain was a long-distance runner. Or
Why does that matter?
one witness says, I used to watch him run in the parking lot on breaks from work. But because someone said he was a runner, and because he went into cardiac arrest after ketamine was injected, well, it must be the ketamine. That's not proof. That's an assumption. They have not proven beyond a reasonable doubt that these gentlemen are responsible for the death of Elijah McClain, or that these gentlemen did anything to assault him, or to give him ketamine for any other purpose than trying to treat him, trying to treat what they reasonably believed was excited delirium.
Got about a half minute.
Thank you, Raymond.
Thank God. That's 30 seconds, y'all.
What did he
And it's on 1.5. What's up, Yamaha? How you doing, buddy?
For assaulted Elijah McClain? He was the company officer. He made sure the scene was safe. He was on the radio.
Hey,
Giving
Yamaha.
directions to the ambulance to get them there. As the company officer, he tells them what tools they need: ketamine, soft restraints, gurney. When the ambulance gets there, he goes and gets the gurney and brings it to Mr. McClain's side. Then he takes the computer and starts inputting important medical information for the medical record.
Okay, your time's about up.
From his standard of care as the company officer. He did
KLI is here,
He's not
Danielle.
They are
Welcome
both
back.
not guilty.
Looking at folks come up real quick.
Ooh.
Yes, it's my man. My man's going to do the rebuttal closing.
Through the magic of
Yeah,
YouTube.
Yamaha, you're going to want to see this rebuttal closing, I think. I think he's going to hit on all the points you wanted. What's 15 times 15. Should I know that? I should, but I don't know it.
225?
Whatever Val said.
Is it? I think it's 225.
My daughter would do it like this. Hey, Siri.
225. Why are you asking a lawyer for math?
2800, 21
Yeah.
806. The parties and counsel are present. The jurors are back after a short
You
break.
should know better.
Rebuttal close from the prosecution.
Wait, what did KLI say?
These defendants,
Yeah, I guess
Nice,
so.
Darth.
and Elijah McClain,
Nice.
like he was a problem, not like he was their patient. Mr. Pello stood up here an hour ago and said that the police just put Elijah McClain into that category of non-compliant. So did
Who was
these
doing the
defendants.
math?
Because the moment the defendant Cooper walked up next to Elijah McClain
Oh,
and heard,
because I said that
oh, here's another young man
30
fighting
seconds.
with police,
Oh.
he put him into that category. He's a problem. And from that
That's
moment
very
on,
hard, Mads. Okay, let's
there was
listen.
not a single thing that Elijah McClain could have done to save his own life. Because when defendant Cooper walks up, Elijah McClain says, ow, okay. The police are hurting him. He is sensitive to pain. He's feeling pain. He is in reality. But in defendant Cooper's mind, he's not paying attention to indications that Elijah McClain's not delirious because he's already picked him up and put him into that category. Problem, non-compliant with the police. So when Elijah McClain, clear as day, says, I can't fix myself, Mr. Cooper, long before this body slam happens from one of the police officers, announces his plan. Well, we'll just leave him there. Because he is in that category. He is a problem because he's just another young man fighting with police. So when the police then slam Elijah down on the ground, just because he says, ow, sorry, and I can't fix myself, does the defendant change his behavior at all? No. He repeats exactly what he started saying before the body slam occurs. We're just going to leave him there until the ambulance gets here. Because if you have somebody that you think is a problem, who's just another young man fighting with police, then it's a lot more convenient. It's a lot easier if you don't get close to them, you don't look at them, and you don't try and determine whether they actually have excited delirium or not. You just leave them there, like you just announced, until it's time to max them out on ketamine. And that's exactly what you see on the video.
Oh.
This is as Mr. Cooper walks up.
No. When we try to stop him, dude,
Come on.
What? Oh, the
Is there anything in English or anything?
he speaks English.
camera.
He's
He speaks
But
English.
he's-
That's
he's
so
definitely not self-
offensive.
not. Okay, at least he wants to.
Okay.
Stop messing around. Chill out.
Well, we'll just leave him.
You've already been told several times, stop.
I can't fix myself. Ow.
Just leave him there until the ambulance gets here, and then we'll just put him down to the attorney.
According to the defendant himself,
This is
He
state's
testified on
this
the
is
stand.
state's rebuttal
he's doing
closing,
there-
so yes.
and from this point on, is a
Matt.
visual assessment of Mr. McClain. That he's supposed to be paying attention to him. That's his whole job. He has medical control of this call and is supposed to determine what is best for Mr. McClain. So then while the police officer, Mr. Rodima, sticks his knee into Elijah McClain's back and starts cranking on his handcuffs so that in this next clip I'm about to show you can hear this horrifying popping sound while he does it.
Stop.
And Mr. McClain screams out, stop, please. While the defendant is supposedly conducting this rigorous visual assessment, he does nothing in response to any of that. And then, while he's supposedly conducting this rigorous visual assessment of his patient, Elijah McClain utters
State's
his last
closing number 2
words
is
on
rebuttal.
earth. Please help me.
Mm.
Leave them there until the ambulance gets here, and then down to the screen.
Hey, I know you're busy, but I just want to let you know that Doc, we had a suspicious call over here on Bill Shield. I was kind of kind of weird, nothing really criminal. My officers go to get contact with him. He starts acting crazy. They attack him. I was glad we ended up trying to put a carotid on the guy. And actually. Well, stop fighting us. I put him out. They were right there. Handcuffs were still struggling with the fire on scene. And
Stop, please. I'm trying. Please help me. This is all right in front of the defendant's eyes. You can even see his face looking over in the direction of the camera here. Elijah McClain is not delirious. He is responding to pain, saying he is trying and begging for the defendants to save his life and to help him. But the moment that the defendant walked up to the scene and heard another young man fighting with police, he put him in that bucket of non-compliant, just like Mr. Pello described. And what that means is that it was
So
ketamine
they
time,
always have the rebuttal
because he was not
closing.
going to bother trying to figure
Because
out
they
if
have
this is one of the vast majority of cases
the
where
burden of
somebody
proof.
has a cause of why they're agitated in custody that's just medical, that's not excited delirium. Dr. Hill told you that. He said I would expect a very small portion of the cases that fall under this
I
excited
have a
delirium protocol
story.
and the
Hi.
agitated patient protocol to actually be excited delirium. He said there's reversible medical causes. And we know exactly what those were in this case. That Mr. McClain was hypoxic. He was short on oxygen because of the carotid hold. We know he aspirated, he threw up in his mask, and that got down into his airway. And because of that aspiration and the struggle, he's acidotic. The acid levels in his system are rising. That's why he's moving in handcuffs and trying to breathe. That is exactly what the defendant was trained to look for. That is exactly what would have been
Thank you,
revealed if he'd done
Val.
any sort of
Thank you.
assessment besides just standing there and looking at him. These statements, stop, please. I'm trying. Please help me. They tell you everything you need to know about Mr. McClain's mental status. But they also tell you some very important things about the witnesses the defendants brought in here. Like the couple paramedics from Memphis, Mr. Ludwig and Miss McKinley. When they come in here and they say, I am certain that this person had excited delirium. That tells you everything that you need to know about the credibility of their testimony. This person is responsive to pain, clearly understands exactly what's going on and is begging for his life. He's not a naked guy crushing down a fence or lifting up a police car. He doesn't have excited delirium. Defendant Cooper has only been here for a few seconds, and he's going to decide to use ketamine in just a few more. You're going to hear, right after this, the conversation between both of these defendants in the background, where they say, do we want narcs or ketamine? And when you hear that conversation, what you're really hearing is on that agitated patient protocol, are we going to go down the left side for regular agitation, for somebody who may not be compliant for medical reasons? Are we going to figure out what's actually happening here? Because that's narcs. That's the benzodiazepines listed on the bottom there. Or are we just going to jump right over to ketamine? Because this makes it a lot easier.
that's where we're at. I just wanted to know, yeah, we did actually quite sure on it tonight, so. And the other one, I don't, oh, you got him? Oh, I didn't know that. Okay, I didn't be busy. Just one other thing, we did have an officer get.
Yeah, that's all his, dude. That's what he was wearing.
Okay, that was very minor.
So the ambulance gets here, we're gonna go ahead and give them.
All the cops are okay.
Yeah, sounds good. Perfect, dude. Perfect.
Perfect,
Far
perfect.
from being disgusted by this body slam or by the officer driving his knee into Elijah McClain's back and cranking on his handcuffs so hard you hear that popping sound. The defendant is jumping right on board. Let's get him some ketamine. That'll be easier for all of us.
Perfect, dude.
He's been
perfect.
next to Elijah McClain for about 90 seconds. You have now in front of you the sum total of information upon which he bases this horrifying decision to max Elijah McClain out on 500 milligrams of ketamine.
This
It
guy's
gets
good.
worse. There's another 5 minutes and 25 seconds between this decision and when he actually injects the ketamine into Elijah McClain. There's all kinds of opportunities where Sergeant Leonard says, hey, make sure he can breathe.
He's very good.
Where one of the officers leans over Elijah McClain and says, hey, you all right? And there's no response.
Yeah, this guy's good.
There's off-ramp
This is
after
the guy that I
off-ramp for the
hate
next
and
5
love.
minutes and 25
Yeah.
seconds where the defendant could take his foot off the gas in this blindfolded car. But he doesn't. Because as soon as he got on the scene, that decision was made. Another young man, and we're just going to give him ketamine. Now,
What he meant to say was another black young man.
this is not a situation where there is some good faith effort.
I'm kind of glad he didn't.
Due to their best efforts, they just made a mistake.
Might have been uncomfortable with that segregated courtroom.
These
but-
defendants did not even try. And that's why we're here.
This guy,
It's
he's gonna
right.
try to go over to the
Not
white
here.
side.
They come up.
Just gonna
All they
stand.
do is look at Mr. McClain, ignore
Or
every
woman.
one of his words, and immediately make
Come
a
on,
decision to do the
everybody, scoot
worst
over.
possible thing. Give him a big overdose of ketamine that he doesn't need. And then after they choose to do the worst possible thing, in the
Agreed,
worst
don't
possible
work.
dose, they leave him there prone
But
on the
that is
ground.
what he meant to say. He stopped
Again, do
himself.
nothing. They literally could have sat inside their ambulance, or excuse me, inside of their fire engine, walked up to Elijah McClain once the ketamine showed up, jabbed him with an overdose, and then gone back and sat in the ambulance until he got taken there by the police. And every single thing in this case plays out the same way. That is how atrocious this was. They didn't even try. Elijah McClain isn't delirious. And the defendants are jumping on board with what's happening here. You remember when Mr. Cooper said, oh yeah, I wanted to go jump in and help restrain his legs. When an officer said he was tired, I was gonna go join in this physical restraint. But for some reason, even though he's totally fine and wants to, in fact, go jump onto Elijah McClain's legs to help with the restraint, it would just be impossible to do this. Had they even tried, done the basic ABCs, they would have found out what's really happening. Elijah McClain is hypoxic, acidotic, and he's aspirated. Even Dr. Dragovich agrees. Dr. Dragovich has a lot of problems. I mean, he accuses Dr. Mitchell of confabulating his report in a perfectly logical, completely factual sentence. And then Dr. Dragovich goes on to say things that are not supported by any evidence, like Elijah McClain was off wandering in traffic. But even he agrees that Elijah McClain has aspirated. If you just listen to somebody's lungs, put a little stethoscope there, get your ear down close. As you heard from Dr. Buther, you could hear those things. Dr. Dragovich also tells you that we would know if the ketamine caused aspiration too, because we would have seen vomit coming out of Elijah McClain's nose on the gurney. Well, apparently his poor review of the factual record extends to that, because on the video, Sergeant Nunez's camera, it very clearly shows vomit streaming out of Elijah McClain's nose and mouth, and you hear the same thing from the people who were on the scene. Now, Dr. Sundaram, there's a lot of problems with his idea that this is a cardiac problem. It's disproved by the autopsy microscopic results. It's not consistent with the video. But even if you were to try and believe what Dr. Sundaram is saying, it just makes the defendants guilty in a different way. Because of what's happening here is a cardiac arrhythmia and a fibrillation that causes cardiac arrest. There's a real easy way to have found out that there's a cardiac pulse problem.
Yeah.
And instead, the defendants choose the worst possible thing to do, to give 500 milligrams of ketamine in this situation. As Dr. Buther said, they're blindfolded driving this car, shoving their foot on the gas. The charges in this case are reckless manslaughter, first and foremost. Despite what the defendant's attorneys told you, that does not mean they had to have a plan to kill Mr. McClain. That just means that their reckless actions killed him.
Thank you, dude.
You don't need to consider criminally negligent homicide unless you think that the actions are not quite to the level of recklessness, not quite to the level of conscious disregard of unjustifiable
he
risk,
just
but
contradicted
instead just
his
represent a gross deviation from the standard of
co-counsel.
care.
With
Did you
what?
hear that?
With what
He
part?
said He said, despite what the defense has been trying to tell you, they didn't have to have a plan to kill Elijah McClain, which they didn't. And we were saying that from the beginning. But remember, his co-counsel got up and said they had a plan.
Well, they probably realized it wasn't as effective as they hoped when they broke.
Mm-hmm.
That'd be my guess. He's like, yeah, that didn't land quite how we wanted it to. Hi,
Yeah.
Texas Jen. How are you, babe? Welcome.
And then there's 2 assault charges, one for intending to cause bodily injury, injecting Mr. McClain with ketamine, but then unintentionally causing serious bodily injury, his arrest and his death. And then finally, unlawfully giving him that ketamine without his consent. Now, when you go back into that jury room to deliberate, it's going to be up to you how to proceed. The first thing you'll be asked to do is select the foreperson. Sometimes the natural thing is to select the foreperson, the loudest person in the room. But remember, you all have to return a unanimous verdict, no matter what that is. So sometimes it's best to pick a person who listens well, who can build consensus and help people to agree on difficult issues. And then you will decide how you want to proceed with your deliberations, what you want to talk about. But let me suggest one thing. We've been in this trial for a long time. I was clean shaven. It might be hard to remember some of the witnesses from early on in particular. And their testimony is important, as is everyone's. And before jumping into your camp, so here's what I think, here's how we should
That's
vote,
supposed
here's
to
what we
say
should
bow
do.
tie dispute.
I remember when that happened.
Talk about it. What was useful about their testimony? What was wrong about their testimony? Potentially most important, how credible is their witness and why? Now, there's a wide group of experts in this case who agree that Elijah McClain died first primary from a pulmonary arrest. Dr. Sina, the neutral autopsy person who just happened to catch this case. Dr. Moss, the only witness in this trial who actually treated Elijah McClain as a patient and actually evaluated him in the hospital, says that this was a primary
I knew he was going to
arrest.
leave.
And it was only after Elijah's lungs stopped working that his heart stopped.
Brandon.
But then talk too about the quality of these experts. Because the people.
It was last
brought
night?
you
It
some
wasn't
incredible
last night.
doctors.
It was weeks ago.
Dr. Robinson, who teaches at Harvard, a preeminent anesthesiologist who uses drugs, sedatives like ketamine day in and day out. And oh man, when you saw him talk about the studies, he knew them backward and forward. He is a master of that literature of what we know about ketamine. Dr. Buther from here in Denver, world-renowned
Thank you,
pulmonologist whose
Brandon.
patients literally travel the globe to come see him for one specific reason. Because he's so good at figuring out what's wrong with folks. And Dr. Mitchell, who literally wrote the guidance paper that the National Medical Association uses for examining in-custody deaths. Probably the preeminent expert on trying to figure out what happened, why people died when they're in police custody. Who did the defendants bring you? Dr. Dragovich, the confabulator, a pathologist from Michigan, I don't know why, of all the counties in the United States, with no particular credential related to this case, whose bias is evident from the moment he opens his mouth. Dr. Sundaram, seems like he's a pretty good cardiac I forget even the title of his name, electrophysiologist. He didn't even look at the microscopic slides of Elijah McClain's heart.
Damn.
The information he was fed was incomplete. And he doesn't even understand how
Is he
aspiration
drinking
works.
again?
He testified
No, he
that
just
it would have
can't
taken 2 days for
spell or
somebody to die
read.
of aspiration. Even the paramedics know that if aspiration is undetected, if you have a lot of it, it can just block your airway completely and you can die almost immediately. Dr. Robinson explained a really crucial issue in this case, what it means to get what they're calling a therapeutic dose of ketamine. Whenever you heard that word therapeutic dose, what it meant was a dose you're supposed to get in a hospital with a doctor there. Because Dr. Robinson explained how the literature lays this out. There's a low dose that's sub-disassociative, so it doesn't even cause you to lose that connection with reality. That's 1 to 3 milligrams. And then from 3 to 5, there's that dissociative dose. That's that ceiling level that we heard talked about from Dr. Hurd and from Dr. Robinson, where you don't get more disassociated after that. This is also what's pre-hospitally cleared to be used. But once you get up higher to that 6.5 to 13 range, that is only supposed to be used in a hospital with a doctor there standing by, monitoring your airway, with all the equipment already attached, hooked up to make sure, ready to intubate you at a moment's notice. Because that is an anesthetic dose. It's therapeutic. We use anesthesia to help people when they go into surgery. So it is therapeutic in that sense, but it is a hospital safe dose. It is not a pre-hospital safe dose. And with the overdose that the defendants gave Elijah McClain, he's up there. He's at 7.7 on this scale. When Dr. Hill testified that there's a wide safety envelope for ketamine, he said it was because it could be given in 3, 4, or 5 milligram per kilogram doses. And that he'd even heard in some places they go up to 6. That is a wide safety profile. That's a big range from 3 to 5 or even 3 to 6. But that's not what the defendants gave Elijah McClain. They gave him 7.7, way outside the safety envelope for pre-hospital settings. And the defendants knew that that increases the risk of side effects. And Dr. Hurd and Dr. Robinson testified to that. Dr. Hurd said it is in excess of the recommended dose for the protocol and is by definition an overdose. And I want to make an important distinction here because defense counsel has been kind of trying to mix two ideas together. That they're saying that a ketamine overdose really only occurs when you have 10 or 50 times the level of ketamine in your blood that you're supposed to. That's a toxic dose of ketamine, where the ketamine just kills you because you're just so overwhelmed with ketamine. That is not what happened here. What happened here is Elijah McClain got a very unsafe hospital type of dose of ketamine that caused respiratory depression, hypersalivation, predictable, known, obvious consequences. And then because nobody was monitoring his airway and he's swallowing and breathing in all of that red vomit we see on the video, his airway gets occluded, he has respiratory arrest and he dies. Dr. Hurd and I made this great chart on the piece of paper over here. This is the dose that Elijah McClain should have gotten, 325 milligrams. Had he weighed 220 pounds or even more, could have been a 300-pound defensive lineman for the Broncos. The maximum dose that ever would have been permissible.
Good visual.
And then, and only after you've given somebody that and they're still fighting and still out of control, the protocol would permit the paramedics to call back, talk to a doctor on the biophone and say, we gave this guy 500 and he's still out of control. Can we give him more ketamine? And the doctor at that point in time could authorize only 250 milligrams more of ketamine. In that scenario, a 220-pound to 300-pound person who gets a max dose is still going crazy, and then you call a doctor and get permission, then you could have given that person 7.5 milligrams per kilogram. But Elijah McClain got even more than that. He got more than you were supposed to give a defensive lineman who you'd already max dosed, who you'd call a doctor for permission, and then max dosed a second time. That's how outside the range of safe pre-hospital and protocol consistent ketamine this was. But the real thing is that the right dose was 0 because Elijah McClain didn't have excited delirium.
That's right.
Any agitation that he showed was obviously from the fact that he was having trouble breathing. There was no need for a single milligram of ketamine. Dr. Hurd, the defense's own expert, admitted to you that the side effects, the risks like respiratory depression, go up when the dose goes up. Yep. And that's in their training too. They knew about it. I want to talk and just finally put this coronary artery thing to bed, because there are some big differences in the quality of evidence examined by Dr. Sundaram and the other doctors in the case. First, Dr. Sundaram, even though he supposedly was so concerned about what could be seen on the heart, whether it was wraparound, whether there was evidence of collateral circulation or not, he never bothered to have a conversation with Dr. Sina, who saw the heart. But Dr. Mitchell did. Dr. Sundaram testifies that you can't even die from aspiration unless it's a couple of days later. That's important because it demonstrates that he has such a narrow focus just on cardiac electrophysiology. All he does is burn little things in the heart. He doesn't understand the holistic picture here, but Dr. Sina does, or excuse me, Dr. Mitchell does, and Dr. Sina does for that matter. But most importantly of all, Dr. Mitchell, who has a concentration in cardiac pathology, was actually teaching courses on cardiac pathology as he was leading up to this trial. And he testified is currently running a study on cardiac pathology to be published in the future. He ruled this out because if the narrowed artery is causing problems downstream, if that's causing an arrhythmia or a fibrillation, it would only do that because the heart's not getting enough blood downstream. So that's why he cut the microscopic slides. And he said, I examined the ones distal or downstream from the narrowed artery, and there was no evidence of damage to those cells. So we know for a fact that this was not what killed Elijah McClain. Dr. Mitchell described it. We took more sections, we looked under the microscope, and there simply just aren't the changes that would be consistent with any major effect from that narrowing of the coronary artery. Dr. Cena ruled it out too. He said that he believes there was collateral circulation.
Did you say
that
Dr.
other
Cena?
blood
Name
vessels
is
had
John
naturally
Cena.
developed. Running 3, 4, 5, 6 miles every single
Hi,
day.
Ellie. How
Often
you doing?
running several miles just from the bus stop to get to work. Of course he would have collateral circulation. And when you're talking back there, I would urge you to consider witness credibility, because in this trial, you've really seen evidence of the thin
I
red
want
line
to cook,
and the thin
and I
blue
don't
line.
even know how to cook. So
The
that's a bad
paramedics and the
sign.
police on the scene come in, and you can see their thumbs on the scale with their testimony. And there are some ways in which it's clearly unreliable. But most importantly, there are a lot of important ways in which the defendant's testimony is unreliable. This is what Mr. Cooper says.
Okay. Where did you administer it? Patient.
If I remember correctly, it was the right deltoid, so his right shoulder area.
Okay. And
Whoa.
while you were administering it, do you remember what the patient was
That
doing?
seems excessive.
Still actively fighting.
What?
Anytime that the patient would try to
That
get placed on
emoji
his
with
side, he would
very serious
try to walk up to the
GUN.
embankment, try to
It's a
fight
Lego
all the
guy.
officers. So
Why
as
does he have such a big
took the
old?
contour aside, administered
Wow.
the medication.
Some of us do. That's
What
all.
was he doing
Some of us
as you were
do.
administering the ketamine? Still resisting, trying to crawl up the grassy embankment. You can see on the video he's completely inert and not moving a single muscle. Why is the defendant so grossly misrepresenting these facts only a couple weeks after the incident? He clearly knows
A
what
big
happened.
old
This was a big
GUN.
deal. Somebody poured out under their watch. Detective Ingwe says that he set up
Drive
this
safe,
interview
Danielle.
with the defendants through their attorney like a week beforehand. They've had plenty of time to think about this incident and figure out what they're going to say in this interview. Then he's asked at any time, does he stop resisting? He says, no, sir.
Okay. How long do you?
And that interview is in evidence. You can watch the whole thing. Then defendant Cooper makes up this other idea and says, I tried to get them to have the patient rolled onto his side to look at his airway and monitor his breathing. But of course, that's nowhere on any of the camera footage. He never asks anyone
When a
to
girl
move
walks
Elijah
in with an itty bitty waist and
They're
around
doing it to
thing
move to
in
the
my
green.
face, I get from.
And he clearly knows why it's important, because he says it's to look at his airway and monitor his breathing.
To try to get
He's consciously disregarding the risks to Elijah McClain's airway from the ketamine and getting the ketamine in that prone position. Their protocols say don't restrain them in the prone position. They talk about why it's important because it can impair the airway and breathing. And then they tell you the technique that you, during the time somebody's in restraints, chemical or soft, continuous attention to their airway, circulation, and vital signs is mandatory. Continuous, mandatory, not let him sit there for 5.5 to 6 minutes and then finally check once you're in the ambulance. Their training reinforces these ideas that they need to be worried about patients who are in the prone position because they can't expire off carbon dioxide, CO2. That means they can't clear acidosis. They're being warned and trained on the exact things that are happening to Elijah McClain. In opening, Ms. Began said to you, oh, look at this
Interesting.
video. He gently
It's
reaches
top
in
news
up,
on all the
checks the
outlets,
product, checks the
actually.
pulse there.
Crazy.
And then Mr. Cooper
Like
doubled down
on
on the stand and
YouTube
said,
right
I
now.
placed my hand in this region here to try and
Even
feel
Law
where
and
his carotid
Crime
pulse.
hasn't been getting really high views on it.
That didn't happen.
No. But it's like I think
His
people
hand goes
thought
down on
it
Elijah's
was never
back,
gonna
on his
turn
scapula,
into what it did.
and it never moves a millimeter until that hand comes up and off of Elijah McClain. You can see how far down his back it is. It's way down by where the jacket's at. So why is Mr. Cooper telling you, oh, I took his pulse? Why is that part of the defendant's opening statement? Because they know how crucial it is. It's literally the ABCs. Dr. Caroline tells him exactly how to do it. And Mr. Ludwig testified about why that stuff is important. Because if you don't even know the patient's pulse, how are you possibly going to figure out what's wrong with them? Mr. DeJesus agrees. Didn't look to him like anybody touched Mr. McClain's neck. Mr. Bradley agreed. Didn't see anyone take Elijah McClain's pulse before the ambulance.
Oh, their views have jumped
Alicia
significantly
Ward, whose
in
hands
the
are in that
last
photo because she was
24
holding Mr.
hours.
McClain's head.
Yeah.
Did you see any of them take any vital signs? Nope, she didn't see it either. And even the defendant's own expert, the very last series of questions I asked him, he said, in his professional
Interesting.
opinion, he is certain to a reasonable professional degree of certainty.
everybody thought it
based
was
on his
gonna be a
35,000 calls that this is
different
not taking
results,
pulse.
I think.
The defendant is not credible. And the reason he's saying these things is to just try and give himself an excuse.
I thought it
for
was going to
doing
be interesting.
such
That's
a
why I
horrible
streamed it.
job and killing Elijah McClain. He is trying to cover up the recklessness of this
Turned out to
conduct,
be
the
brutal.
disregard of the risks to Elijah McClain. So
Interesting,
instead
though.
of saying what Elijah McClain actually
Yeah.
says, please stop. I'm trying. Please help me. He describes it as a lot of gibberish.
A
And then
lot of
says
gibberish. That's
a couple
so
of times,
effed up,
I tried
man.
to ask him questions like a name. No, he didn't.
No, he
He
didn't.
didn't.
At no point in time did he try and ask Elijah any questions.
Not once.
I
So
didn't
why
like this guy,
is he
but
making
he's
this
still
up?
on point.
Because he knows how fundamental it is. That if you think somebody is suffering from excited delirium, they are delirious and they are not connected with reality. So that's why they teach them to ask questions. It's the obvious thing to do. If I asked you with no medical training, how would you determine if somebody is delirious? Your answer would be, I will ask the person some questions and see if they are making sense.
Yeah, duh.
So he has to say this kind of stuff to try and cover up for the fact
Hi, half
that he just
Irish.
jumped to excited delirium.
Did you have any communication with the patient?
It was pretty close to a
He
month.
didn't have
It
any
wasn't-
communication with me. It didn't seem like he was ever forming any
This is such a
sentences.
lie.
A lot of gibberish, a lot of yelling, things that I couldn't understand.
Gibberish.
They weren't
So
words, they were
fucked
just
up.
noises, grunts, things like that. There was a couple times that I approached the patient, trying to ask him some questions as far as a name, any kind of medical problems.
When they go
but
on to lie about it like
providing
this,
any kind of
Matt.
sensical language back as an answer.
Well, I think
minutes.
Kim
Thank
Potter should have been charged too.
A couple of times I tried to ask
She
him his
wasn't?
name
She was.
and about new medical
She
problems.
was. I think they
Because
got
he
the right
knows
call on that
how
one. I think.
fundamental, how paramedic 101, how ABC, those types of questions are, and he knows he never did it. And instead, he just jumped to a max dose of ketamine. If you're ever wondering whether Mr. Cooper was paying enough attention to notice, I can't even believe how silly this is, but it's true. Elijah McClain is begging for his life, saying, please help me. And in this
so
video, Mr.
sad.
Cooper does not even respond. And then a couple of seconds later, a cop sneezes and he tells him, bless you. He's clearly listening.
This is
actually,
so
stop fighting us.
crazy.
They put him out, they were able to get him under handcuffs, we're still struggling with him by a fire on scene, and that's where we're at. I just want to let you know, yeah, we did actually apply for audit tonight, so.
Bless you. Thank you.
He can hear perfectly well. Somebody sneezes in the background, bless
He
you.
said, bless
But
you
when
to
Elijah
the cop
McClain
that sneezed,
says,
but he
"Stop,
did
please.
not help
I'm trying."
Elijah,
And
who was
pleads for his life.
actually asking for help.
No response. This is the individual that they had down on the ground. This is exactly the same clothes he was wearing, except instead of the red hoodie, when the defendants encountered him, he's got nothing on his face. You can see how tiny he is. It's a size medium jacket. It's in evidence. Go look at it.
Yeah, he was tiny.
Even his shoes are in evidence.
Well, it
If
goes.
you're wondering whether Dr. Dragovich is right that there's a heavy winter coat back.
It goes back to my thoughts on all of this, right? My personal belief is that if you're bestowed this authority by the state, if we the people have allotted you the authority to walk around and stick people with ketamine or carry a pistol to stop somebody
Yeah.
from committing a crime, then you should be held to a higher standard. In the Kim Potter case, she made a mistake and it ended that man's life because she pulled a pistol rather than her taser. I think
So that's
that
a
she
problem.
should be held criminally responsible for that. I understand it was a mistake. It obviously wasn't like murder one or malicious in any way. But I think that they made the right call with convicting her of whatever the hell it was, reckless, I think, or something.
So she was convicted?
Yeah.
Oh, I didn't know that.
Yeah, Kim Potter was.
Okay, and wait, that's not it. Hold on. Where did it go? Nope. It keeps going up. Okay, yes, I get this, but the Cooper said that he, like, on the stand, they were asking him about, like, if he had heard Elijah begging for help, remember? And he had said, like, no, I guess, like, there was so much going on. I don't remember if it was Cooper or the other one, Peter. But regardless, one of them was like, no, I couldn't, like, there was so much going on, I couldn't hear him saying anything. It was just gibberish. So the fact that he said, bless you to somebody who was, like, right there, he could hear what was happening,
Wait a minute.
I think. She's
I
talking
think
about
if I
the
remember
Kim Potter.
right. If I remember the case correctly, I think that the charges were okay in that one. And she is out of jail already. I mean, it wasn't like she spent in years and years and years, right? She got punished and that's what that was. This is the same thing. These guys injected the man with ketamine thinking that it was just another day at the office or whatever, and it ended up losing his life. And it's a touchy subject, and I think that that's probably what should happen, Matt. I think that a lot of these need to get looked at, and some of these protections shouldn't be as widespread as they are. Yeah. But now that I'm thinking about it, though, like she was kind of in the car, and there was a little more to it than that, and I don't remember the exact details. But yeah, she definitely pulled her pistol instead of her taser and shot him.
Back there, go look
What's
at
wrong?
it. How can you possibly look at this person who's saying, "I'm sorry, I'm trying, please help me," and say he's 220 pounds and out of control? The entire defense hinges on this idea that they were acting within the scope of their medical license. But one requirement is that they actually have to be acting under the direction of a duly licensed physician. If they're outside the protocols, this doesn't apply. They also have to reasonably believe that they're promoting the health of a patient.
That's
But
also
it's so
correct,
clear from
Farrell.
Cooper's statements that he is just skipping directly to excited delirium without doing anything, and that he's just treating this for convenience. And then finally, it also would have to be the case that a reasonable person would consent to the medical treatment, and nobody would agree to catch.
Let me clarify. I'm not trying to say that these two cases are the same. I'm saying
You said it was the same thing.
I didn't mean to say that they're just the same thing like that. It's the authority bestowed on these people needs to be held higher than it would be for a normal person or whatever, right? Like they need to be held to a higher standard. Police officers, EMTs, VA doctors, like whatever the hell you want to call it, right? I think they just need to be held to a higher standard than somebody else.
This is true, Mads.
Seems right.
Mm-hmm.
I wasn't trying to say that this is the exact same factually. That's not what I meant. Let me re-clarify.
Yeah, dude. I mean, you know your
Certainly not
chat
to
better than that.
There's no legitimate medical purpose for what's going on here. It's just excuses.
I'm actually glad that you
The
pointed
witnesses
that
are
out,
all
Farrell.
consistent.
Thank
about
you.
that. And the protocol that's in evidence confirms it as well. That's the standard.
I
of care.
just stated
The
it
standard
in
of
my
care is
chat.
What Travis Chambers explained to you that they're supposed to do, how he trained them. What Dr. Hill explained to you, what they're supposed to do, how he trained them. Even Mr. Ludwig admits, I don't make the standard of care. It's in these protocols. But they didn't follow the protocols. Instead, they used ketamine as a chemical restraint, when they're specifically prohibited from using any kind of restraint as a punishment or for the convenience of the crew. Certainly, this appears to be the most convenient option. Even defendant Cichuniec admits he's not following the protocols. He says that he thinks the appropriate dose would be 425, but then goes up to 500 because of extra agitation. He admitted in that box on the right, that's from his trial testimony. That was the wrong dose. He agrees.
About 1 minute.
Thank you, Your Honor. And when they give these overdoses of ketamine, they're conscious of the risks and they're disregarding them because they're trained. That's the ketamine training slide. That appropriate dosing is what's needed to maintain somebody's respiratory drive. And large dosing increases the risk of things like respiratory depression. In this interview clip, defendant Cooper can't remember any of the other side effects except the one that killed Elijah McClain, respiratory depression. At the end of the day, it's just like Dr. Buther said. This is reckless. It's not intending to kill. It's intending to cause pain, bodily injury, and stupor. It's not intending to kill, but it is wildly, insanely reckless. It's the medical equivalent of putting on a blindfold, jumping in a car, and hitting the gas as hard as you can. This was the worst possible care, very much in quotation marks, that Mr. McClain could have given. Like I said a few seconds ago, if they just stayed on the fire engine and done nothing, showed up and given 500 milligrams, the max dose they could give of ketamine, totally blind, and then gone and sat in their ambulance for the 5.5 to 6 minutes until Elijah McClain was brought there on the pram.
The drink.
Oh, this is number
this
2.
goes down exactly the same way.
You missed the first
really?
one. Yeah.
Right, your time is about up.
Thank you, Your Honor. And the key to this case is that's how bad it was. That the defendants didn't even try. And when Elijah McClain pleaded, please help me. They
You
left
missed
him
the
there.
first one too, Harris.
They overdosed him on ketamine. They left him there again, and it killed him. And that's why they're guilty.
Stop watching your numbers.
You and each of you solemnly swear or affirm in the presence of law that you will, to the utmost of your ability, keep the jury together in a private and convenient place, that you will not permit any person to speak with them. or
BL
speak
Blazy,
to
that
them
was
yourselves unless
confusing.
by order of the court.
It
except
was,
to ask them if they have
I'm
agreed upon a
90%
verdict, and
positive
they
it
have
was
agreed, you
drawn.
will return with them into court.
90%.
At this time, I have to announce who the alternates are in this case.
Hi,
Originally,
Flash.
Welcome
we
back,
selected
buddy.
3 alternates that
Oh.
would serve if one of the other 12 jurors became ill or otherwise. The alternate jurors in this case are the jurors in seat number 11, who is juror number 12, and the juror who's in seat number 12, who is juror number 13. I want to remind you that I choose the seat numbers for the alternate jurors randomly before I even know who is summoned for jury service in this case. This is by no means a reflection of your performance as a juror. You just happen to end up in the seat number that was randomly designated before the trial for the alternate jurors. In just a few moments, I'm going to give those jurors 12 and 13, and seats 11 and 12, the opportunity to gather up your belongings. But importantly, and I'll stress importantly, I hope that everybody remains healthy and doesn't have an emergency during the deliberations. In that vein, I'm not discharging jurors 12 and 13 from your jury service yet. I'm simply excusing you temporarily. Please continue to follow all of the instructions I've been giving you throughout the trial, because there is a chance, and I hope it doesn't happen,
Do it.
that one of the deliberating jurors could
Tell 'em to.
unexpectedly become unavailable. I may be in a position I would need to call you to replace that juror. And as far as that goes, you may go on about your life as if you were doing before you first reported for jury service, but you must continue to follow all
Right,
of my
Mads? We
instructions until
don't
my
need to
staff
hear it.
notifies you that you are actually discharged
We
from your
don't need
jury
to hear
service.
this. He's just telling them
So,
blah, blah, blah.
Again, for those 2 jurors, 12 and
Yeah.
13,
He's
you
just
shouldn't
saying,
be
like,
forming
you're
or
still,
expressing
you
any
can still
opinions or
be
discussing
called
the case
later.
with anybody
They're not going to call him.
until you're actually excused from jury service.
I skipped
Do you
ahead.
folks understand what I'm explaining? Okay.
Oh, is his brother really
And,
hot?
what
Get
I'm
him
gonna
on
do
here.
is I'm going to have one of my staff members escort the 2 of you out.
Get him
We'll try to
on
get
here
some good information how to
now.
contact you in the hopefully unlikely event that one of the deliberating jurors becomes unavailable. So I'll excuse you at this time with the thanks of the court, and I'll need to instruct the 12 jurors who will deliberate a bit further. All right, at this time, I'm going to have the 12 jurors go back into the jury room. It's looks by that clock on the wall, it's a little bit after 5. The court was informed earlier today that one of the jurors has a family event that they have to be at not too long from now. So what I'm going to ask you to do is take your notebooks with you when you go into the jury room. We'll let you know that we lock the jury room door and we put a sign on the door so the cleaning staff won't go in there and mess anything up. We will be bringing you the verdict forms as well as the evidence that was admitted in this case. You should not take your notebooks anywhere else
Look how
after
cute I made
retiring
my
unless
ear look.
specifically instructed to do so by the courts.
Like it
By
looks
the
like
court
it sticks
rather,
out.
and as I said, the evidence and
Does it not stick out?
exhibits and
Well, not like that.
jury
Really
verdict
cute,
forms
like
that
a
we've never
Dumbo
back
ear.
there. It's important to bear in mind that you may discuss this case
You don't have
only when all
earlobes.
12 of you are together in the jury room
I have
and all of you are
earlobes.
present.
No, you don't.
You
Not
should
the hangy kind.
Attempt to discuss this case with other jurors.
Ah,
Oh
or
yeah,
dangly.
mine are
jurors
attached.
at any
Yeah.
time
Mine aren't
except when
dangly.
all
Mine
of the
are
12
attached
jurors
to my
are in the
face.
jury room.
That's what I said.
Again, I will caution you
Yeah.
at this time, you should not attempt to conduct your own
Some people's are
investigation of any
attached to
facts.
their face.
And that means no consultation
I
with
was just making
dictionaries,
an
the internet,
observation.
or any other sources of information.
Also,
The verdict
sometimes
must be based
if you have a
solely on
baby,
the
they might
evidence
say
admitted
that
in this
their
case and applying
ears
it to the
hang
jury
low.
instructions that you were
Do
read
they
given.
wobble to and fro?
What I'm going to do is just have you folks go back there and get situated.
Do your
And
chain
then,
hang low.
quite
does
frankly,
a
I'm going to
wobble
release
to
you
a
for the
Bro,
evening,
can
but I
you
would
throw
like to
them
have you
up?
back
Can
at
you
8:30
throw them
a.m.
up?
We
Can
will
you
bring
throw
you
'em over your
straight
shoulder
into
like
the
a-
jury room. As I said, the evidence that's been admitted should be back there for you to examine, and you will
Thanks.
likely be beginning your deliberations tomorrow morning.
I had a
With
little
that,
preemie baby,
again,
and I swear to you,
I've
she
used this
had the
example before, but
cutest
it's
freaking ears you
as
have
far as
ever
I
seen
know,
in
a
your
true
life.
story. And
I
that
wish I
is,
could show y'all. They were so
long
cute. They were
trial,
like
longer
this
than this
big.
one actually, that occurred in the East Coast of the United States, and it was again a high-profile case. After the verdict came in, the one of the sides that was in the case decided to do data mining. And actually, there are folks, IT folks, that are pretty good at it. And what they realized is during the trial, the jurors got to know each other pretty well, of course, because it was a long
Y'all
trial.
see that light?
And we're
It's
texting back and forth
crazy.
about the case to the tune of 7,000 text messages.
Whoa, dude.
Holy
That
shit.
ended up having a new trial, of course. So you need to follow the instructions, as I mentioned yesterday.
Did you hear what he
there are a lot
just
of
said?
That was a
instructions in this
lot of
case,
text
and you've all
messages.
Holy
ratio of time and
shit.
attention. So please follow my instructions. I'll ask to be back at 8:30, as I said.
That
to
was a
bring you
good
right back
warning.
to
I've
jury room
actually
to
never
continue
heard one like that.
deliberations. Drive safely and try to think about something else when you go home.
I think we're done with this one. Get there, get there, get there.
I think I scared off Brandon
We're calling it. He's still here.
because he wants to see the Allen charge.
He's still here. Present this one? No, that's your stream. This one. Up.
Look
All
how
right.
cute this is.
I'm going into this one blind, y'all. I have no idea where I need to be in this video, so we're gonna find it together. Oop. The hell? Nobody cares about your
Probably
opinion.
jury questions or something.
Nobody cares about that guy's opinions.
Nobody. Literally nobody.
They're here to watch me and McKinley, not you. Here we go. I think. Oh, play, bitch.
I mean, that's not a good profile. I mean, I hate to be rude, but he looks angry.
Yeah, they both look like they could be
Like
on
killers?
trial for Charleston thing.
For killing people?
Calm down. Calm down, McKinley.
Reckless manslaughter, one for reckless manslaughter, and one for criminally negligent homicide.
What?
What?
Here, rewind.
Because there's no way for them to mark.
That was when the camera picked up.
Nuh-uh, really?
Yeah.
Oh, that's annoying.
What the hell are you talking about?
Reckless manslaughter, one for reckless manslaughter, and one for criminally negligent homicide. Because there's no way for them to mark on the verdict form that they have appropriately. Because the line one says we find not guilty for reckless manslaughter and the lesser included of criminally negligent homicide, or we find guilty of one of the two. So there's really no way for them to answer it on the form that they have.
Well, that's stupid. Y'all fucked up there.
Is this
I think
supposed to
there's a
be
case that
live
kind
stream?
of addresses that.
No.
Two of them that are noted in the full GE 7E:17, and those would be People v. Lewis 676 Pacific 2nd 682.
I feel like the judge doesn't know he's being live streamed right now.
And I think they segue that into Richardson case. So that's our quandary for the moment.
I think on behalf of Mr. Cooper, Judge, we would ask that we figure out how to fix that verdict form then so that they could do that.
Yeah.
If they are unanimous as to, for example, not guilty as to reckless manslaughter, it would be appropriate for them to return that and to indicate that they're on a lesser.
Yeah. Duh. Obviously, you
Well,
have to
would
fix
you
that.
like me to?
Yeah,
well,
collect them and fix
I
them,
don't
asshole.
want them just sitting
Oh.
back there. Conceivably.
Didn't mean to say that about the judge.
I can.
Unless you ever plan on
been asked to do.
I
Taking the
had
Colorado
dreams. I had
bars.
dreams. You don't even have to take it. All you have to
verdict
do is
form
just
that
take
I
the
would
ethics
use
part.
in
I
a
had dreams of
situation
doing
such
this.
as this.
Not
In
anymore.
Colorado?
So
Yeah.
what my thought would be
Interesting.
is
Just stay out of Aurora.
bring them in here. And,
Oopsie, sorry,
you know,
Mr. Judge. I did not
further
mean it.
As far as
It was
the
the
first two
cider.
questions, if I give them the Allen instruction, if that's the way it rolls out,
Oh,
we
okay.
should have
Good.
plenty of time to develop a set of verdict
No, it's
forms or
orange
something that
cranberry.
might accomplish what you're asking for.
Oh, never
Um,
mind. Y'all aren't even talking to me.
So I
Yeah, they
think
definitely have the forms
that
already.
will be the first thing that I do.
They've already been in
And,
deliberation for a whole day, I think, at this point.
If it does.
Yeah,
turn
and
out
then they
that
returned
they're all
it
unanimous that they're hopelessly
with-
deadlocked and that further deliberations would not
saying
assist
they're
them.
deadlocked.
I'll just tell them that.
Did I pull up the
we
wrong
need to
stream?
Discuss legal matters.
No,
for
no, they're gonna come out now
while.
in a minute. We just didn't get to
before
hear the
we take
question, I
our
think.
next step.
They're deadlocked
That
on
would be my
a
proposal.
part of it, but clearly they
counsel for,
found somebody
Mr.
guilty on something.
Cichuniec?
Thank you, Your Honor. We don't have any objection to the court proceeding in that fashion. I think,
Oh,
just to be clear, when the court polls the jury about whether or not they're hopelessly deadlocked, whether or not they believe, that individual juror believes that there will be, that additional deliberation will be fruitful, is the court going to give the modified Allen instruction at that point, or will the court send them away and have us draft the modified Allen instruction? Or do you have one already?
Oh, I have one.
Of course you did.
Would it be possible for us to take a look at what the court is going to provide?
Oh, yeah, it's straight.
It's currently
straight out
on
of
1X.
Colgy.
Okay.
It's
I
normal
can
speed
make a
right now.
copy of it.
Thank you.
Let me get to skip another big chunk in here. So we're about done, y'all.
yeah. They have to come in. He has to send them back, and then they're gonna come back again later.
An hour. Yeah, we got about an
Thank
hour,
you, Ellie.
15 minutes left. No, not a mistrial.
Actually,
Not a mistrial.
I would catch a fish. I do. I love catching fish. It's a very weird thing, and I shouldn't admit to that maybe because I obviously don't eat them, but like hopefully other people do.
You can catch and release as well.
I know, but really like every time I've ever caught and released anything, it's like seems like that fish is not gonna live.
Well, usually I don't have that problem.
Really?
Yeah.
You release it and they're just like they just go back to living their little swimmy life?
Yeah.
Oh, not me. No,
Yeah.
mine just float right to the top.
What the hell? How do you fish? With
I
like a
must be
spear gun or
aggressive.
something? See, she thinks she's a lefty, y'all. She just doesn't know yet. She just
Thank
doesn't
you,
know
Your Honor.
yet.
That language, I think, tracks the case, the Allen case as well. So we don't have any objection to the procedure the court has laid out or the proposed modified Allen instruction.
Not eating, but catching.
The people.
We agree with the procedure the court has laid out and have no objection
Oh,
to
no, no, no.
the
Yeah, no,
proposed
not
Allen
eating.
instruction if it is
I wish I
necessary.
could, though.
Fish
I'm
is
gonna get
Okay.
I'm gonna get
We'll bring the
hypnotized.
jurors in and we'll see where we're at.
Why can't you eat animals?
Just because, like, I've messed my own head up.
Oh. Dude.
I know.
We should hang out sometime. I'll just sneak little meat and stuff in your food.
That's what, every person that I've ever dated has told me that. And it's, well, I'm going to be 40 next month and it still hasn't happened.
Well, you're also single, so there's that. Oh, that was mean. I think I didn't mean it to be mean. It might have been mean.
Well, I mean, yeah, I've been a vegetarian since I was 3.
How long have you been a vegan?
Well, I mean, I've been the same thing, vegan, vegetarian. It's like not all the way vegan because I still eat cheese and like I'll eat things that
Then
have
you're not
egg in them.
vegan.
Right. I'm mostly
Here's that
vegetarian.
Okay.
But I won't eat just like an egg that you cook for me, but I will eat a cake
Why?
and that has egg in it.
Why wouldn't
Because
you
it
eat an
weirds
egg?
me out. It just weirds me out. I can't do it.
You know that most eggs are unfertilized and will never develop into a chicken, correct?
I do know that, except that my friend raises chickens and he gets the eggs from them like every day.
Okay.
And
Our jurors have returned. Please be seated.
that's not true.
90% of
He
the
had like
eggs
a
that you
whole
would buy
entire.
All right, the court has
from the
received
store
a,
are unfertilized.
communication
90%.
Oh, yeah,
from
sure.
They have to be.
But it
They
just-
have to.
indicating.
It's the
a
fact that they were like
split,
the
if you
parts
will.
that were gonna make up the
First of
baby
all, I wanna
chicken
let
that
you
weirds
know,
me
I
out.
don't
Like I'm
want
not
to
gonna eat a
know
human
what the
egg.
split is. I don't.
You would if you were hungry enough.
What count or charge the split might be on.
No, probably not.
What charge or charges that might be on. But I'm going to be asking you, each of you, 2 questions. And I'm going to go ahead and start with our juror in seat
My
number
dad
1.
watches, so I'm gonna leave that
With
one alone.
respect to the split, do you believe that the jury is hopelessly deadlocked?
Sorry, sir. I apologize for that.
Do you believe that further deliberations would be of assistance in reaching a unanimous verdict? All right, we'll move to the juror in seat number 2. Do you believe that the jury is hopelessly deadlocked on the count? Do you believe that further deliberations would be of assistance in reaching a unanimous verdict? Do you believe that further deliberations would be of
Hold on,
assistance
listen to this
the
part.
jury in reaching a unanimous verdict? In other words, if you go back and deliberate longer, do you believe that you could reach a unanimous verdict on the split? Sorry? Okay.
No, she said.
Juror
I
seat
heard her
number
say no
3,
too, Brandon.
Do you believe that the jury is
Oh,
hopelessly
they're
deadlocked?
gonna ask every single person.
Do you believe that further
She said
deliberations
yes.
would assist the jury in reaching a unanimous verdict? All right, we'll move to the juror in seat number 4. Do you believe that the jury is hopelessly deadlocked?
Yes.
Do you believe that further deliberations would assist the jury in reaching a unanimous verdict? You do?
Yes.
She said yes.
All right. We'll move to the juror in seat number 6. Do you believe that the jury is hopelessly deadlocked?
Yes.
Do you believe that further deliberations would be of assistance in the jury reaching a unanimous verdict?
No.
All
No.
right, we'll move to the juror in seat 7.
So one
Do you
yes.
believe that the jury is hopelessly deadlocked? All right, I'll go on to the second question then.
What'd she say?
Do you believe that further
I
deliberations?
think she didn't even know if
would
they were
assist the
hopelessly
jury
deadlocked.
in reaching a unanimous verdict? All right, we'll move to the juror in seat number 8. Do you believe that the jury is hopelessly deadlocked?
Yes, sir.
Do you believe that further deliberations would be of assistance in the jury reaching a unanimous verdict? All right, we'll move to the
Didn't
juror
hear that
in
one.
seat number
I didn't
9.
hear that one.
Do you believe that the jury is hopelessly deadlocked?
Yes.
Do you believe further deliberations would assist the jury in reaching a unanimous verdict?
No.
Yes.
All right, we'll move to
Oh, I
seat
thought he said
number
yes.
10. Do you believe that the jury is hopelessly deadlocked? I'm sorry?
Yes.
Okay. Do you believe that further deliberations would assist the jury in reaching a unanimous verdict? Okay.
Didn't hear that one either.
They are so weak.
We'll move to the juror who's actually in seat number 13, I guess. Do you believe that the jury is hopelessly deadlocked?
Yes.
Do you believe further deliberations would be of assistance in the jury reaching a unanimous verdict?
No.
All
No.
right, we'll move to the juror in seat 14. Do you believe that the jury is hopelessly deadlocked? Do you believe further deliberations would assist the jury in reaching a unanimous verdict?
Yes.
And we'll move to the
Oh.
juror in seat number 15.
He said yes.
Do you believe
Yeah.
So that
that
was
the jury
two
is
that said yes.
hopelessly deadlocked?
At least.
Do you believe further deliberations would be of assistance in the jury reaching a unanimous verdict?
No.
No.
I changed my second one too. I didn't know that was an option.
What's that? Okay, and that was our juror in seat number 6.
Yep. 6 changes their answer to yes.
What a fucking moron.
That's what Brandon was so pissed off about. He's like,
What
"These
a
people are
fucking
idiots. I would
idiot."
not want them. I would not want them deciding my fate." Yeah, no. Especially after they're deadlocked, and then he sends them back, and they're like, "Okay, let's get out of here so we
Right,
can go
folks
Christmas
on the
shopping."
jury,
Hey,
since
just
it
cause.
appears to the court that your deliberations have been somewhat lengthy without a verdict being reached, the
Yeah,
court wishes
7
to
hours.
suggest a few thoughts that you should consider
You
in your
can skip through this. This
deliberations
is just the
along
Allen
with the
charge.
evidence in the case and all of the
They don't
instructions
tell you what they're
previously
deadlocked on.
given.
Yeah, we're not sure.
It is your duty as jurors to consult with one another and to deliberate with a view to reaching a verdict, if you can do so without violence to individual judgment.
Your conscience. Oh,
Each
they
of
said
you must
judgment.
decide the case for yourself,
We say
but
There's at
do
least
so
two of 'em in there.
only after impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous.
Yeah, I
But
hate the
do
Allen
not
charge.
do not surrender
Oh,
your honest
sorry.
conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors, or
Oh, damn, I
for the mere
forgot.
purpose of returning a verdict. You are not advocates. You are judges of the facts. Your sole interest is to ascertain the truth from the evidence in the case.
No, it's going to be longer than that.
With that, I will have the jurors return to the jury room to continue their deliberations. We'll bring you a copy of the instruction I have just read to you.
You've been on a jury? I thought the UK didn't do juries. Except for in like a couple civil cases or something, right? You guys don't have criminal jury trials, do you? Yeah, no, they have no fucking clue what they're supposed to be doing.
Yeah, one goes, "I didn't know that was an option."
It's a yes or no question. There's only 2 fucking answers you can give.
Yes?
And you
or
can't
no.
and you
Right,
can't
jurors have stepped out.
believe that you're deadlocked and
I
then
expect counsel
believe that more
will
time
have
would get you
time to
undeadlocked.
formulate in
That's not
case
what
we
deadlock
give a
means.
different answer in the future.
We've got a draft.
Yeah, I was like, I think that we
We'll get
did
that
get
printed
that
out so
from
that
them,
the
though.
court and council can look at it if it becomes necessary.
Okay.
Interesting.
Okay, that'd be great. Yeah, if you could just, once you get it printed out. if
I
you
thought
could
it-
I gotta go.
tell Aisha or Kate know, and they'll.
I got to
bring
heat
it
up
to
my
me so I can take a
cheesesteak.
look
I'll
at
be
it.
right back.
Go for it.
And it's a
All
veggie
right.
cheesesteak, just
Then it's
so
not
nobody freaks
then
out.
it's not a cheese steak. Then it's a cheese vegetable sandwich.
In my consultations with
Yeah.
the chief judge and court security, I don't know that we can keep going all night. So what I would expect that I would do.
Hey, Fed. How you doing, buddy?
Should we not hear from the jury is probably send one of my staff in around 5:30. Say,
Get her, y'all.
it's about ready. We're about ready to call it a day. My experience is if they're actually close to anything, they'll say, we just need a few more minutes, which normally means about a half an hour. And I'll give them some extra time.
Later, Brandon.
But in
Appreciate
the
you, brother.
event that they do reach a verdict, within a reasonable time frame from there, we'll have another half an hour, so that would put us at 6:30.
Oh yeah.
By the time we'd have folks here, enough time to get folks here to hear the verdict. I wasn't given a finite deadline, but 7-ish is what it sounded like to me.
That makes sense.
All right, thank you.
All right. And then magically, through the powers of YouTube, about an hour later, something like that, 2 hours later, they magically have a verdict that they were deadlocked in 2 hours ago because they want to go home now. Because the judge kept them there on a Friday before Christmas, Halloween.
It's going to be called case numbers 21 CR 2800 and 21 CR 2806. People of the state of Colorado v. Cooper, people of the state of Colorado v. Cichuniec. We have the parties in council present. The court was informed several minutes ago, I guess it was, that the jurors have arrived at unanimous verdicts. Are the parties ready to receive the verdicts of the jury?
We are.
Yes, Your Honor. Judge, we do have some folks who are on their way from a location just 5 minutes away from here. So if we can hold 5 or 10 minutes, we would really appreciate that.
All right. We did inform the jurors that there might be a little delay before we read the verdict. So we'll give it a few more minutes.
A cheese and vegetable sandwich.
Oh.
Right, Sue? I don't know how. I don't like the Allen charge.
Yeah, no, it's horrible.
I don't like it at all.
Especially on a Friday night before Christmas. Like, that's just wrong.
The Friday before Christmas, you guys get back in there and give me either a guilty or a not guilty right now. Do it. And they come back in 2 hours.
Be here. Because the threat is like, we'll keep you here all night or we'll make you come back tomorrow. Even though after they left, he clearly acknowledged they were not going to stay there all night. But who wants that hanging over them at Christmas, you know?
Right. And most of these people have no idea, right? Like they don't know how it's actually working. So the judge is like, you have to go back and give me a verdict. Well, the judge wants a verdict. Hey, Jason J. Welcome. Oh, that's no good.
What? Wait, what happened?
Yikes.
Oh, no. That's what my dad is always like, do not take my grandbaby to the mall on the weekend. Like, do not do it. Poor thing has like never been to the mall.
That's not a bad thing.
Santa for the
Why is that a bad thing?
I mean, well, because she just saw Santa for the very first time, like in her whole life.
Okay.
A few weeks ago, she went during the week with my mom, and she was like, "Oh my God, Mommy, guess what happened? Guess who was at the mall?" And if you think about it, it's like kind of creepy that Santa's at the mall.
If you want to get into this, I think it's kind of creepy for a grown man to get paid to have children sit on their lap all fucking day. But that's
Dude, and it's creepy that we lie to our kids.
There's a magical thing there that I do understand and appreciate.
I get it, but also like I was very devastated when I found out that my parents had been lying to me. I was 3, of course. And
3? You found out at 3?
Yeah.
How the fuck did you find out at 3?
Because my dumbass older brother would like wake me up to go downstairs in the middle of the night, and I saw my parents putting the boxes on the side of the house, and I was like, and my brother still believed after that.
He's clearly not the attorney in the family, is he?
He actually is an attorney as well. He's just more gullible than me.
Oh shit. More gullible than you?
Oh no. Feral. Oh my God. That happened the other night too, when I was with Beck, when I was in. Sorry, Farrell. Oh my God, did I do it? Oh my God, I feel so horrible.
Oh my God.
Oh God.
Why are you playing this in front of your children? Honestly, this is not a program for children. Oh
No, I know. It was
God.
like on the expert stream or something. It was like way too late for her to still be awake, right? And y'all like started talking about it. And I was like, hey guys. And she was like, Mommy, why are they talking about?
Oh, that's horrible. That is horrible. Look what you did, McKinley. God.
I feel terrible.
Better watch your numbers and see how far they fall now.
I'm not going to go into it anymore, but it was a whole thing between my parents and I. Like, I was like, very like, I'm not doing this. And they were like, you're going to ruin her life. So here we are. Yes, I am the Grinch. What if she was listening to me?
Who?
My child.
Well, that would be karma, I think. Oh, that's funny. Way to go, McKinley. God.
My God. And Farrell's gone. Now I feel terrible.
Oh, that's funny.
That was funny what Aaron said.
Oh, that's funny. All right, what is happening here? Why do we keep... Get it together, court.
I like that they have like a new... Man, I feel terrible. Oh, I also put something in the oven on broil.
Don't leave that in there too long. Broil will burn things
Somebody
quickly.
did just tell me something about Bastrop. Okay, Ellie. Oh, hold on. Oh.
So your brother's more gullible than you?
Yeah. Oh, because she was... I mean... But dude, I had that same issue though. So, I mean... That's totally possible. And it could be anybody out there. Like, anybody could have been listening, not on headphones. So...
Oh, that's funny.
Where is it? In Bastrop?
What?
Ah, Sugar Rush. Oh, cute. Okay. This Bastrop place that has like Santa stuff. Thank you, Ellie. Why won't you just copy and paste? There we go. Okay, I'll be right back.
Y'all are mean. I fucking love you. I love every one of you, but you're mean. Oh, shit. What is happening here? Why are we just sitting in silence? Come on. Get to the jury. Ooh. I think I just heard McKinley burn herself on the oven.
Your Honor, we are fully ready.
Okay, very well.
There we go.
Folks, we're going to bring the jurors in just a moment. The court certainly understands that there are high emotions that surround this case and cases of this nature, but I will implore people to use proper courtroom decorum when and after the verdicts are read.
Pause it. I will pause it for Yamaha.
Okay, I'm coming.
You're good. I'm pausing it for Yamaha. He needed coffee.
Okay.
We will wait for Yamaha. He's been here almost the entire time. We will wait for him. Oh my
This
God.
channel does not.
She's mean, ruining Christmas. Lol, my 16-year-old is now heartbroken. This channel does not give Santa, Easter Bunny, or Tooth Fairy advice. Oh, that's good. That's good.
Oh, really? Yeah, I know, right? That was a good one.
Oh, that's funny. No, he needs more coffee, he said. He wants me to pause it. I will absolutely pause it for him.
I totally burned my sandwich, by the way.
I told you were gonna. I said, don't do broil. It was a little late, but once I found out you were on broil. Oh, God.
Yeah, I know. I meant to ask you before I put it in, but then
Not
I was just
broil.
like, oh, I'll just do it.
Broil's a direct, very hot direct heat on the surface, and it's just.
Oh, I burned the shit out of it.
That makes sense. Yamaha, let me know when you're back. Oh, that's
I
funny.
can't believe I scheduled a stream for tonight. That was the craziest thing I've ever done.
My man. All right, here we go, y'all.
Okay.
We bring the jurors in.
I got you, brother. It's okay. Your sandwich was crap.
Is that
Her non-steak and non-cheese steak and cheese sandwich?
No, it really has real cheese, though.
Does it? Or does it have like
Yeah.
sliced Kraft singles or cheese whiz
No,
or something?
I think it has real cheese.
Okay. Good. Excuse me for 1 second, y'all. Let me see where the. All right, I'll be right
Are you
back.
playing the verdict without you?
Hopefully not. Hopefully I'll be right back.
It might be a minute.
Everybody, I think I'm going to change my stream, by the way, everyone. It's like I should hang out with my kid tonight, you know? It's Christmas Eve.
Well, I would look at it like this. You're not going to want to do that stream tomorrow or Monday, right? And if your parents are helping with the baby situation, it might not be a bad idea
Yeah.
just to knock it out.
Okay, you're right.
Just saying.
Yeah, and then at least it's like content that people might want to go over and like look at later.
Well, and plus it's something that's just yours, right? Something that
Yeah, I guess. So.
Jurors,
I don't know
have
if that
returned
really
to the
matters,
courtroom.
but
Please
you
be
know what I'm
That
saying.
doesn't matter at all.
It shouldn't. I don't know. I'm
Court
weird.
was informed several minutes ago that the jurors have reached unanimous verdicts. I saw that the juror in seat number 7 was carrying some paperwork. Would I be
KOI.
correct to assume that you are the foreperson of the jury?
I don't remember
And
Flash
has the
Fan,
jury reached
actually.
unanimous verdicts?
I think 7:30 was
All
your
right,
scheduled
I'll
time.
have Ms. Moore collect the verdict
7:30
forms.
Eastern.
Eastern?
I think so.
So 6:30. So like in 40 minutes.
Yep.
No, that's 6:30 my time. Fuck, I can't do math.
Well, it's like
An hour 40.
yeah, you're right. I don't know what time I'm streaming.
Also, don't feel obligated. If you don't want to do it, don't do it.
Yeah. Yeah. What is happening?
They're waiting
Oh,
for
he's
the
having
jury
to
to come
read
in.
all the verdicts.
Sure, he's got to look at the paperwork, right?
You see how they block the door like that?
The bailiffs.
Yeah, but the two people on the end actually are not bailiffs. They're just like court staff blocking the door like that. I never.
Oh, they're
understand
keeping
why they
people
do
from going in and out. They're about to read a potential, years in prison sentence. They don't want people coming in and out or distracting.
Oh, like they don't want the
All right,
defendants
court
running.
has reviewed
Well,
the
that
verdict
too.
Forms.
I never
The verdict
realized
forms
that.
are each signed by the foreperson. The court will first read the verdict forms for case number 21 CR 2800. That is People of the State of Colorado v. Jeremy Cooper.
Oh,
The
they're gonna be
verdict
so
reads as
pissed.
follows. We, the jury, find the defendant Jeremy Cooper guilty of criminally negligent homicide with the signature of the foreperson beneath Roman II.
Criminally negligent. Okay.
People of the State of Colorado v. Jeremy Cooper, jury verdict, charge of assault in the second degree with intent to cause bodily injury causing serious bodily injury. We, the jury, find the defendant Jeremy Cooper not guilty of assault in the second degree, intent to cause bodily injury causing serious bodily injury. The next verdict form, People of the State of Colorado v. Jeremy Cooper, jury verdict, charge of assault in the second degree, unlawful administration of drugs. The verdict reads, we, the jury, find the defendant Jeremy Cooper not guilty of assault in the
Interesting,
second
since he's
degree,
the one who
unlawful
administered
administration
it.
of drugs with the signature of the foreperson. The next are for case number 21 CR 2806, People of the State of Colorado v. Peter Cichuniec. Jury verdict. We, the jury, find the defendant Peter Cichuniec guilty of criminally negligent homicide, again with the signature of the foreperson. Jury verdict, charge of assault in the second degree, intent to cause bodily injury causing serious bodily injury. We, the jury, find the defendant Peter Cichuniec not guilty of assault in the second degree, intent to cause bodily injury causing serious bodily injury. Verdict form, People of the State of Colorado v. Peter Cichuniec. Verdict form, charge of assault in the second degree, unlawful administration of drugs. We, the jury, find the defendant Peter Cichuniec guilty of assault in the second degree, unlawful administration of drugs with a signature line with the foreperson. Beneath that, we further find with respect to the verdict question for this count as follows. Did the defendant and/or the principal cause bodily injury or death? The box is checked yes with the signature of the foreperson. Do any of the parties wish to have the jurors polled?
We do.
Yes, Your Honor.
All right.
I'm so
they're
disappointed in the
leaving?
defense's closing
We'll
statements.
start with the juror in seat number 1.
Are they? They're not
Were
getting up
these
and
and are
leaving right
these
now,
your
right?
verdicts?
Who? Nobody's leaving.
Juror in seat
Okay.
number 2. Were these and
person's
are
trying
these your
to.
verdicts?
Yeah.
Juror in seat number 3. Were these and are these your verdicts? Juror in seat number 4. Were these and are these your verdicts? Juror in seat number 6. Were these and are these your verdicts? Juror, seat number 7, our 4-person, were these and are these your verdicts? Juror in seat number 8, were these and are these your verdicts?
Yes.
Juror in seat number 9, were these and are these your verdicts?
Give me just a second, Sue.
Juror in seat number 10, were these and are these your verdicts? Juror in seat number 13, were these and are these your verdicts?
Yes.
Juror in seat number 14, were these and are these your verdicts?
Yes.
Finally, the juror in seat number 15, were these and are these your verdicts?
Yes.
Folks, I want to thank you for the time and attention and patience that you've had
happened?
throughout this trial. Without folks like you who are willing to put in this time and effort, one of the most important pillars of our democracy would fall, and that is the pillar of a jury trial.
What did he just say?
Folks being tried. The pillar of a jury trials of our democracy would.
We don't
fall.
have a democracy, you fucking
The pillar of
douche.
a jury trial of folks being tried by folks from the community, from different walks of
Why are you
life,
being
with different
mad?
perspectives.
Because he's called it a democracy. That's all.
To make
It's not a
these
democracy.
decisions
We don't
rather
have a
than
democracy.
in
We don't
many
live in a
countries,
democracy. We didn't
a
write a
religious,
constitution for
military,
a
or
democracy.
government
We live in a
official.
constitutional republic.
The question may now arise of whether you can talk to folks about the case or what you thought about the case. The answer to that is as much or as little as you wish. If anybody persists in speaking to you over your objection, you should make me
Okay.
aware of that so I can remedy the
So
situation.
this is a thing in your
If
chat.
anybody becomes critical.
This is a
Okay.
of
thing
your
with
service
anybody
as a
that
juror
believes in the
this case,
Constitution.
you should
And it
also
should be a
let me
thing
know
for
about that.
everybody.
And
But like real amped about
with
it.
that, I'm going to have my staff take you back into the jury
It's
room for a few
gaslighting
moments.
the people is what it
There's a
is.
few things I need to do. I need to speak with you for just a few minutes. I know it's getting kind of later in the evening or later in the afternoon. I don't intend to keep you very long. So,
All right. I don't think we
take
need
the
to
jury
watch the
back
last
into the
like
jury
4
room.
minutes, do we? Nothing's going to be exciting about this.
I just want to see what happens with the people that are exiting.
Okay. We can watch it.
And I also want to see the officer get taken into custody if they're going to show that. Because Cichuniec, or however you say his name, gets taken into custody because of the 2nd-degree assault. So he's like in jail until sentencing because he's getting a
All right,
prison
please be
sentence.
seated.
But Cooper's not?
I mean, he might be, but it's something about like the charge that Cichuniec.
We will try to find a
It was like an enhancement charge
sentencing
that
date that works for folks.
Cichuniec was charged with.
Oh. So, okay. So he's got like an enhancement to his negligent homicide charge.
We'll make it work.
Mm-hmm.
Yes.
That's why he's facing like 16
All right.
years
Well,
or 14 years
based
or
on the
something.
verdict for the count for Mr. Cichuniec with the sentence enhancer, it's the court's understanding that pursuant to Colorado law, particularly Article
That
2,
sucks.
Section 19 of the Colorado Constitution, Mr. Cichuniec must be remanded to the custody of the sheriff.
Wow.
The court will continue the bond for Mr. Cooper. And the court will order a pre-sentence investigation report. Any other
Like, how do you think the prosecutors feel about that, though?
sorts of review that the parties may wish.
About what exactly?
About the fact that a paramedic's getting taken into custody, like, to go serve his prison sentence now.
They
Look at
brought the
this, like-
charges.
I know, but do you think they feel good about themselves? Like, yeah, we got him.
I think they feel like they got to win
That's
and it's going to
weird.
help their career.
Advisement to ask the court to renew that motion with respect to the 2nd-degree assault. I mean,
It's all about that win percentage, McKinley.
This time.
All right, the court has considered that may come up at this time. However, it has not been, based upon the prior record, the court will deny the motion without prejudice. The court will allow the parties to further brief it for the court.
What was the motion?
I don't know, because he wouldn't use a
think
mic.
with respect, and it was brought up, I think, in the context of the constitutionality of the, but the motion for judgment.
Directed
acquittal,
verdict,
the court will
maybe?
deny, but the court may revisit
No,
the
it's too late for a directed
constitutional aspects of it.
And Judge, I would ask the court to stay the order to remand Mr. Cichuniec based upon that finding. I don't. Our reading was that, at least for the law, that it was not mandatory to be for him to be remanded. That if the court were to be sentencing Department of Corrections, that he would be remanded, but we would ask him not to be remanded. The court state that order.
So the court's planning on sentencing
Well,
him to
the
prison.
way that the court reads Article 2, Section 19 of the Colorado Constitution and the
No,
enabling
they can't do-
legislation.
Well,
And in
yes,
addition to
they
that,
could
the
do that.
case of People v. Austin, found at 419 Pacific 3rd, 587. Specifically, the court's discussion in paragraphs 12 and 13, it deals with bail after conviction, and that's where we're at. So the court will deny the request.
Just another couple seconds, y'all. And then we'll get into
Oh,
it.
that's sad, man. Can you imagine being an officer and arresting a paramedic?
The court will be in
On
recess.
Christmas Eve or Eve.
Eve. All
Oh,
right,
they didn't
y'all.
even show it. See, they chickened out because if that was a regular defendant, we would have gotten to see the whole thing. Him
Oh,
get
yeah.
put in the cuffs.
Oh, yeah.
Get
We would've
taken
got the
back.
perp
We would have
walk.
gotten to see him. Yeah.
We would have got the perp walk. All right, y'all. So in case you missed it, Cooper, who was the paramedic, he was charged with negligent homicide. And Cichuniec, the lieutenant, now
I mean, he was
captain-
convicted of.
Convicted,
He was
yes, sorry.
convicted.
I said charged. I meant convicted. Correct. Thank you so much. Cichuniec was convicted of negligent homicide with assault in the second degree for the illegal administration of drugs.
And he was
which-
also convicted of criminally negligent homicide.
Yeah, I said that.
Oh. Did
So
you say Cooper?
him too, both of them. They were both charged with or convicted of negligent homicide, and
Yeah.
Cichuniec got assault to illegal administration of drugs, which is an enhancement on his negligent homicide, right?
Yeah.
So-
They said it's an enhancer.
Okay, so
So-
what that means is that it will make his sentence longer. Basically, that's basically what it means.
Yeah. And apparently there's a statute that's in Colorado that says regarding bail after a conviction when you have that enhancer, you're not allowed to just get bail. You have to be remanded to custody. So he's going to be in custody until he's sentenced. Thanks, Brandon.
Dirty liberal. I think that's probably the negligent homicide. I think I'm okay with, honestly. I think that they failed to make sure that their patient was okay, and I think that administering the 500 milligrams just to chemically sedate people is a negligent act. So I think I'm okay with this verdict. Yeah, I think I'm okay with everything that just happened there, to be completely honest.
So I find it a little weird, although I said this from the beginning. Remember when I said that, remember how Cooper had to get Cichuniec, however you say his name, had to get his authorization in order to give the ketamine. Actually, wasn't it Cichuniec who told him to give it?
Yes, it was under Cichuniec's orders.
Right. He ordered him to give it, and all
Correct.
he did was give it to him. So I'm glad that the jury at least that
Saw that.
was way more. That was justice.
Yeah,
at
I think
least
that
in terms of that.
as far as the convictions went, I'm okay with it. I think it was probably the right call. I know that some of you are going to disagree, and that's okay. We can disagree. Look at the panel. We got a liberal and libertarian, I guess, more than anything on panel. You good?
Yeah, it's like either a house is falling or there's thunder.
Could go either way. Hopefully it's not your house. But that's what, I think it's important to be able to disagree. I think society is getting to the point where that's becoming harder and harder for people to disagree and still maintain friendship, conversation.
Yeah.
At the very least, a pathway for progress, right?
Mm-hmm.
That sounded lame. That sounded lame as shit.
Oh, it sounded like democracy.
Oh my God, shut up. You and your blue friends are ruining the fucking... let me see who is live right now, y'all.
Nobody. Because it's
Somebody's
Christmas
going to be
Eve.
live. There's always somebody live. It's YouTube.
Civil Discord. Oh, I thought you meant that was like a channel.
All right, y'all. I've got... Let me see what they're doing first before I put it up to a vote. We got to vote between... Oh, no. I know exactly where we're going. Never mind.
What?
We are going to go to Crime Spies, who is a new channel. She's got...
Yes.
She's got a small channel. She's got 275 subs right now, and she's covering Zachariah Anderson stuff. So we're going to go over there and show her some love and let her know that Valhalla and McKinley got her back. How about that?
Yeah. And Merry Christmas, Happy Holidays. Y'all be safe. Be
Merry
super
Christmas.
safe if you're out driving.
Yes.
Yeah. Have a great holiday. And
Safe travels.
I'll be streaming later. Val, are you going to stream it all in the next few days?
Undecided. I'm not sure what the
Okay.
hell. I'm sure I'll be somewhere. You guys know I'm everywhere on YouTube. I'll be somewhere. I'm not sure if I'm going to be streaming my own stuff. That's what else I got. Brandy Churchwell is confirmed for the January 20th Lego build, y'all. Brandy Churchwell is a true crimer. It's gonna be a lot of fun. We're getting some different genres in place. We're getting some different crowds to come into these Lego streams. I think
different crowds. True crime is a different crowd.
It's different than LawTube. It's different. It's similar, but it's different. It's gonna be fun. I can't wait to do it. I can't wait to get to
gonna be exciting.
know Brandy and ask her a few questions and
see her doggy.
Good things on the horizon, y'all. Do you know Brandy Churchwell?
I've watched her lots of times.
Oh, okay.
But no, I don't know her.
Okay, but you know who she is. You watch her channel.
I've watched her many a times.
Cool. All right. Merry Christmas, everybody. I might be on Winning Reality's channel tonight. I'm not sure. I got to see what the wife's up to. Otherwise, I love and appreciate every one of you. And Merry Christmas, Happy Hanukkah, Happy Kwanzaa, Merry Kwanzaa. I don't even know what the right terminology is there. Kwanzaa is a fake
We don't
holiday.
know, Brandon. What's the name of? Isn't it Brandy Churchwell or
13th Juror? Brandy Churchwell,
yes,
13th Juror.
13th Juror.
That's her channel name. And what did I say? The 20th, right? January 20th, she'll be on the channel. We're also going to do a stream on January 13th. Not entirely sure who the guest is yet, but we're hashing it out. We're getting there. Y'all, Merry Christmas.
Baker will be streaming Christmas Day.
Baker will be. Love y'all.
In case I don't see ya. Good afternoon. Good evening.